Chapter 10, slide up, it's important.
Court are called upon to determine the validity of the group of companies doctrine in the jurisprudence of Indian arbitration. The doctrine provides that an arbitration agreement, which is entered into by a company within a group of companies, may bind non-signatory affiliates if the circumstances are such as to demonstrate the mutual intention of the parties to bind both signatories and non-signatories. This doctrine is called into question purportedly on the ground that it interferes with the established legal principles such as party autonomy, privity of contract, and separate legal personality. The challenge before this court is to figure out whether there can be a reconciliation between the group of companies doctrine and well-settled legal principles of corporate law and contract law. The arguments advanced by counsel on both sides of the aisle indicate that this constitution bench has been primarily called upon to determine the validity of the group of companies doctrine in Indian arbitration jurisprudence. However, there are other broad ancillary issues which have been raised by the council. These include, one, whether the Arbitration Act allows the joinder of a non-signatory as a party to an arbitration agreement, and two, whether Section 7 of the Arbitration Act allows for determination of an intention to arbitrate on the basis of the conduct of the parties. This bench will address the issues arising out of the order of reference as well as the above-mentioned ancillary issues in due course. It's a generally accepted legal proposition that arbitration is a matter of contract and the party cannot be required to submit to arbitration any dispute which they have not agreed so to submit. Since consent forms the cornerstone of arbitration, a non-signatory cannot be forcibly made a party to an arbitration agreement, as doing so would violate the sacrosanct principles of privity of contract and party autonomy. However, in the case of multi-party contracts, the courts and tribunals are often called upon to determine the parties to an arbitration agreement. The general method to figure out the parties to an arbitration agreement is to look for the entities who are named in the recital and have signed the agreement. The signature of a party on the agreement is the most profound expression of the consent of a person or entity to submit to the jurisdiction of an arbitral tribunal. However, the corollary that persons or entities who have not signed the agreement are not bound by it may not always be correct. A written contract does not necessarily require that parties put their signatures to the document embodying the terms of the agreement. Therefore, the term non-signatories instead of the traditional third parties seems the most suitable to describe situations where consent to arbitration is expressed through means other than signature. A non-signatory is a person or entity that is implicated in a dispute which is the subject matter of an arbitration, although it has not formally entered into an arbitration agreement. The important determination is whether such a non-signatory intended to effect legal relations with the signatory parties and be bound by the arbitration agreement. There may arise situations where persons or entities who have not formally signed the arbitration agreement or the underlying contract containing the arbitration agreement may intend to be bound by the terms of the agreement. In other words, the issue is who is a party to an arbitration agreement, and that is primarily an issue of consent. Reading Section 7 of the Arbitration Act in view of the above discussion gives rise to the following conclusions. First, arbitration agreements arise out of a legal relationship between or among persons or entities which may be contractual or otherwise. Second, in situations where the legal relationship is contractual in nature, the nature of relationship can be determined on the basis of general contract law principles. Third, it is not necessary for the persons or entities to be signatories to the arbitration agreement to be bound by it. Fourth, in case of non-signatory parties, the important determination for the courts is whether the persons or entities intended to or consented to be bound by the arbitration agreement or the underlying contract containing the arbitration agreement, though their acts through their acts or conduct. Fifth, the requirement of a written arbitration agreement has to be adhered to strictly, but the form in which such agreement is recorded is irrelevant. Sixth, the requirement of a written arbitration agreement does not exclude the possibility of binding non-signatory parties if there is a defined legal relationship between the signatory and non-signatory parties.
And seventh, once the validity of an arbitration agreement is established, the court or tribunal can determine the issue of which parties are bound by such agreement.
Arbitration law is an autonomous legal field, while the main purpose of corporate law and contract law is imputation of substantive legal liability. The main purpose behind the law of arbitration is to determine whether an arbitral tribunal has jurisdiction over the dispute arising between parties to an arbitration agreement. On the one hand, the courts and tribunals cannot lightly brush aside the decision of the parties to not make a person or entity as a party to the arbitration agreement.
The fact that the non-signatory did not put pen to paper may be an indicator of its intention to not assume any rights or responsibilities under the arbitration agreement. On the other hand, courts and tribunals cannot adopt a rigid approach to exclude all persons or entities who, through their conduct and relationship with the signatory parties, intended to be bound by the underlying contract containing the arbitration agreement. The area of arbitration law not only concerns domestic law, but it also encompasses the international law, particularly when it pertains to the enforcement of international arbitral awards. Therefore, this court ought to adopt a balanced approach without compromising on the basic principles of arbitration law, contract law, and company law to ensure that the resultant legal framework is consistent with internationally accepted practices and principles. A formalistic construction of an arbitration agreement would suggest that the decision of a party to not sign an agreement should be construed to mean that the mutual intention of the parties was to exclude that party from the ambit of the arbitration agreement. Indeed, corporate entities have commercial and contractual freedom to structure their business in a manner to limit their liability. However, there have been situations where a corporate entity deliberately made an effort to be not bound by the underlying contract containing the arbitration agreement, but was actively involved in the negotiation and performance of the contract. The level of the non-signatory party's involvement was to the extent of making the other party believe that it was a veritable party to the contract and the arbitration agreement contained under it. Therefore, the group of companies doctrine is applied to ascertain the intentions of the parties by analyzing the factual circumstances surrounding the contractual agreements.
The group of companies doctrine was developed by international arbitral tribunals, specifically in the context of arbitration, and is not generally used in other areas of law. Although the existence of a group of companies is a necessary condition, it is not the sufficient condition to determine the intention of the parties. In almost all formulations, courts and tribunals have cautioned that the mere membership of a non-signatory in a group of companies is not enough to bind it to the arbitration agreement. Rather, the courts need to determine first the existence of a group of companies and second, the conduct of the signatory and non-signatory parties which indicate their common intention to make the non-signatory a party to the arbitration agreement. Thus, the group of companies doctrine is similar to other consent-based doctrines such as agency, assignment, assumption, and guarantee, to the extent that it is ordinarily applied as a means of identifying the common intention of the parties to bind the non-signatory to the arbitration agreement. As the group of companies doctrine is a consent-based theory, its application depends upon the consideration of a variety of factual elements to establish the mutual intention of all the parties involved. In other words, the group of companies doctrine is a means to infer the mutual intent of both the signatory and non-signatory parties to be bound by the arbitration agreement. The relationship between and among the legal entities within the corporate group structure and the involvement of the parties in the performance of the underlying contractual obligations are indicators to determine the mutual intentions of the parties. The other factors, such as the commonality of the subject matter, composite nature of the transactions, and the performance of the contract, ought to be cumulatively considered and analyzed by courts and tribunals to identify the intention of the parties to bind the non-signatory party to the arbitration agreement. The party seeking joinder of a non-signatory bears the burden of proof of satisfying the above factors to the satisfaction of the court or tribunal, as the case may be. We are of the opinion that there is a need to seek a balance between the consensual nature of arbitration and the modern commercial reality where a non-signatory becomes implicated in a commercial transaction in a number of different ways. Such a balance can be adequately achieved if the factors laid down under discovery enterprises, supra, are applied holistically. For instance, the involvement of the non-signatory in the performance of the underlying contract in a manner that suggests that it intended to be bound by the contract containing the arbitration agreement is an important aspect. Other factors, such as the composite nature of the transaction and commonality of the subject matter, would suggest that the claims against the non-signatory were strongly interlinked with the subject matter of the tribunal's jurisdiction. Looking at the factors holistically, it could be inferred that the non-signatories, by virtue of their relationship with the signatory parties and active involvement in the performance of commercial obligations, which are intricately linked to the subject matter, are not actually strangers to the dispute between the signatory parties. One of the questions that has been referred before us is whether the phrase claiming through or under in section 8 could be interpreted to include the group of companies doctrine. The group of companies doctrine is founded on the mutual intent of parties to determine if the non-signatory entity within a group could be made a party to the arbitration agreement in its own right. Such a non-signatory entity is not claiming through or under a signatory party. As mentioned above, the phrase claiming through or under is used in the context of successors in interest that act in a derivative capacity and substitute the signatory party to the arbitration agreement. To the contrary, the group of companies doctrine is used to bind the non-signatory to the arbitration agreement so that it can agitate the benefits and be subject to the burdens that it derived or is conferred in the course of the performance of the contract. The doctrine can be used to bind a non-signatory party to the arbitration agreement regardless of the phrase claiming through or under as appearing in sections 8 and 45 of the Arbitration Act. In Chloro Controls, this court joined the non-signatory entities as parties to the arbitration agreement in their own rights on the basis that they were signatories to ancillary agreements which were closely interlinked with the performance of the principal agreement containing the arbitration agreement. This court in Chloro Controls reasoned that the non-signatory parties, being a part of the same corporate group as the signatory parties, were subsidiaries in interest or subsidiary companies and therefore were claiming through or under the signatory parties. As held above, the phrase claiming through or under only applies to entities acting in a derivative capacity and not with respect to joinder of parties in their own right. Therefore, we hold that the approach of this court in Chloro Controls, to the extent that it traced the group of companies doctrine to the phrase claiming through or under, is erroneous and against the well-settled principles of contract and commercial law. As observed above, the existence of the group of companies doctrine is intrinsically found in the principle of mutual intent of parties to a commercial bargain. In case of joinder of non-signatory parties to an arbitration agreement, the following two scenarios will prominently emerge. First, where a signatory party to an arbitration agreement seeks joinder of a non-signatory party to the arbitration agreement. And second, where a non-signatory party itself seeks invocation of an arbitration agreement. In both the scenarios, the referral court will be required to prima facie rule on the existence of the arbitration agreement and whether the non-signatory is a veritable party to the arbitration agreement. In view of the complexity of such a determination, the referral court should leave it for the arbitral tribunal to decide whether the non-signatory party is indeed a party to the arbitration agreement on the basis of the factual evidence and application of legal doctrine. The tribunal can delve into the factual, circumstantial, and legal aspects of the matter to decide whether its jurisdiction extends to the non-signatory party. In the process, the tribunal should comply with the requirements of the principles of natural justice, such as giving an opportunity to the non-signatory to raise objections with regard to the jurisdiction of the arbitral tribunal. This interpretation also gives true effect to the doctrine of competence by leaving the issue of determination of true parties to an arbitration agreement to be decided by the arbitral tribunal under section 16. In view of the discussion above, we arrive at the following conclusions. A. The definition of parties under section 2(1)H, read with section 7 of the Arbitration Act, includes both signatory as well as non-signatory parties. B. Conduct of the non-signatory parties could be an indicator of their consent to be bound by the arbitration agreement. C. The requirement of a written arbitration agreement under section 7 does not exclude the possibility of binding non-signatory parties. D. Under the Arbitration Act, the concept of a party is distinct and different from the concept of persons claiming through or under a party to the arbitration agreement. E. The underlying basis for the application of the group of companies doctrine rests on maintaining the corporate separateness of the group of companies while determining the common intention of the parties to bind the non-signatory to the arbitration agreement. F. The principle of alter ego or piercing the corporate veil
cannot be made the basis for the application of the group of companies doctrine. G. The group of companies doctrine has an independent existence as a principle of law which stems from a harmonious reading of Section 2(1)H along with Section 7 of the Arbitration Act. H. To apply the group of companies doctrine, the courts or tribunals, as the case may be, have to consider all the cumulative factors laid down in discovery enterprises. Resultantly, the principle of single economic unit cannot be the sole basis for invoking the group of companies doctrine. I. The persons claiming through or under can only assert a right in a derivative capacity. J. The approach of this court in chlorocontrols, to the extent that it traced the group of companies doctrine to the phase claiming through or under, is erroneous and against the well-established principles of contract law and corporate law. K. The group of companies doctrine should be retained in the Indian arbitration jurisprudence, considering its utility in determining the intention of the parties in the context of complex transactions involving multiple parties and multiple agreements. L. At the referral stage, the referral court should leave it for the arbitral tribunal to decide whether the non-signatory is bound by the arbitration agreement. And M. In the course of this judgment, any authoritative determination given by this court pertaining to the group of companies doctrine should not be interpreted to exclude the application of other doctrines and principles for binding non-signatories to arbitration agreement.
To answer the questions of law referred to this constitution bench in the above terms, the registry shall place the matters before the regular bench for disposal after obtaining the directions on the administrative side. My learned brother Justice Narasimha, this one I just said. Mr. Divan has gone somewhere else. That curative petition, we have clarified in the judgment, Mr. Divan, that your curative petition, you have a case that the curative petition should be dismissed as it is on the facts. That we have kept open for that to be considered.
That's a different case. Man.
Oh. No, but here also, sorry.
One is a concurring judgment with some additional reasons.
So basically, we have upheld the group of companies doctrine, but we have said that chlorocontrols was, in that sense, erroneous. Both Brother Narasimha and I have said that chlorocontrols was erroneous by relying on claiming by or under. That's fine. A lot of cases are pending only all over the country.
Much.
Yes, correction.
Me.
Just quickly point out a few submissions with respect to the articles of the Constitution. I just completed part 2. Before that, just one point of, I think, correction. Mr. Sibal had interjected yesterday and suggested that the Nandita Saikia study had compared pre-reorganization Assam statistics with post-reorganization. Now, we've checked it up, and I'll just give you 2 pages. This does not seem to be correct because the authors have been very careful. I'll just give you the pages. At pages 2956 and 2957 of volume 4, below both tables 2.6 and 2.7, the authors specifically indicate that they have considered the period consistent and the areas consistent with the 2011 census boundary of Assam. So that you may just note, there is a specific notation which has been made by the authors below tables 2.6 and 2.7. They've gone on the basis of the 2011 census by which reorganization took place, and they have compared as far as the earlier period is concerned with those same districts, etc. So that's just a point. Now, if I may just if your lordships could just take up the Constitution, please. Just a few articles that I want to place. So first is, of course, Article 13(2). The state shall not make any law which takes away or abridges the rights conferred in this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So I wish to just emphasize, even an abridgment ought not to be countenanced if your lordship finds that in fact you have there is such an abridgment. The other couple of articles that I wanted to point out was 29(1). We'll make our submissions on that, but 29(1), protection of interests of minorities. So it comes under the heading cultural and educational rights. And as far as 29(1) is concerned, any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. And in our respectful submission, the impact which this impugn provision has directly impacts our ability to conserve broadly our cultural rights, but specifically also aspects of distinct script, distinct language. Then please go to Articles 326 and 327. Elections to the House of the People and to the legislative assemblies of states to be on the basis of adult suffrage. The elections to the House of the People and to the legislative assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by the appropriate legislature, and is not otherwise disqualified under the Constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to be registered as a voter at any such election. And 327, power of Parliament to make provisions with respect to elections to legislatures. Subject to the provisions of this Constitution, Parliament may from time to time, by law, make provision with respect to all matters relating to or in connection with elections to either House of Parliament or to the House or either House of the Legislature of a state, including the preparation of electoral rolls, the delimitation of constituencies, and all other matters necessary for securing the due constitution of such house or houses. So here, as far as registration of voters is concerned, covered by Article 326, in our respectful submission, this is specific to a citizen of India, and therefore There are two elements to this. One is, of course, the strict scrutiny test, because our submission is going to be that this is really having an impact on the integrity of India. It's having an impact on the sovereignty of India. This decision, which is the impugn provision. And in as much as it so does impact, a strict scrutiny ought to be applied while examining the validity of the law. But here, 326, as you have seen, citizenship is sought to be conferred. I'll just complete by making a reference to 355, which has two aspects to it.
Duty of the Union to protect states against external aggression and internal disturbance. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried out in accordance with the provisions of this Constitution. And here we have, of course, the advantage of a judgment in Sonowal 1
with respect to the external aggression aspect. But here, this is also, there is a notion also of internal disturbance. And in our respectful submission, this statutory provision is such that it would lead to internal disturbance. It encourages and causes internal disturbance in parts of the country. And therefore, as far as 355 is concerned, Your Lordship will keep that facet in mind. Now, my lords, may I request you to please take up
Citizenship Act. Here, you will notice that 2B Your Lordships have it? Do you have it separately? Yeah. So I'm just indicating that illegal migrant is defined in 2B, means a foreigner who has entered into India without a valid passport or other travel document and such, or with a valid passport or other travel document, and such other document or other authority as may be prescribed, etc. And then you will also find that there in 2H, you have a definition of undivided India. Means India as defined in the Government of India Act 1935. Now, just before placing section 6A, you will notice that there is
in section 3 citizenship by birth. So that's one manner of obtaining citizenship. Citizenship by descent is covered under section 4.
Citizenship by registration. Now here again you will find that there is an exclusion, not being an illegal migrant. Under section 5, subsection 1, citizenship by naturalization. Here again, pursuant to an amendment in 2004, not being an illegal migrant has been recorded or inserted. And as far as section 7 is concerned,
citizenship by incorporation of territory.
Now I proceed to the impugn provision, which is 6A. So first please see the marginal note itself. Special provisions as to citizenship of persons covered by the Assam Accord. So this is my first point, and this is very, very specific only to Assam. For the purposes of this section, Assam means the territories included in the state of Assam immediately before the commencement of the Citizenship Amendment Act 85. B. Detected to be a foreigner means detected to be a foreigner in accordance with the provisions of the Foreigners Act 1946 and the Foreigners Tribunals Order 1964 by a tribunal constituted under the said order. So this is an expression which will come, detected to be a foreigner. Specified territories means the territories included in Bangladesh immediately before the 1985 Act. D. A person shall be deemed to be of Indian, this is very important, a person shall be deemed to be of Indian origin if he or either of his parents or any of his grandparents were born in undivided India. E. A person shall be deemed to have been detected to be a foreigner on the date on which a tribunal constituted under the Foreigners Tribunal's Order 64 submits its opinion to the effect that he is a foreigner to the officer or authority concerned. So here you will find that the expression opinion is utilized, and at some places it's a form of a determination. Now look at subsection 2. Subject to the provisions of subsection 6 and 7, all persons of Indian origin who came before 1st January 66 to Assam from specified territory, including such of those whose names were included in the electoral rolls used for the purpose of the general election in the House of the People held in 1967, and who have been ordinarily resident in Assam since the dates of their entry into Assam, shall be deemed to be citizens of India as from 1st January 66. So I want to make 2 or 3 points here. First, as far as 1st January 1966 is concerned, it operates in a blanket manner. There is no determination, etc., which is involved at all. There is no process at all. Deemed to be a citizen of India as from the first day of January 1966. So there is no process. Now there's a second point I want to emphasize. Please see the expression has been ordinarily resident in Assam since the dates of their entry into Assam. And you will find this also in the next subsection. This, in our respectful submission, the effect and the impact of this particular provision is that people will continue to remain in Assam, one. And number two, it serves as a beacon to attract people to come to Assam and make whatever claim, false claim, etc., etc. What you find is, it's not just that on a particular day there is some determination. By holding that the person should ordinarily be resident in Assam since the date of entry, you are creating a situation where, because you will find that there's no time limit which is prescribed for any of these determinations under subsection 2, subsection 3, etc. There's no outer time limit at all which is prescribed. It can be done today. There's no problem. I mean, if this particular section is valid, you can make an assertion today, and that's it. So this is another feature in subsection 2 which you will notice. So 3 features. First, it's blanket and there is no conditionality which is to be met. There is no process provided for the purposes of determination. And third, there is a very strong encouragement to people to remain ordinarily resident in Assam since the time that you enter and to make a claim. Now please see subsection 3. Subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam on or after the first day of January 66, but before the 25th day of March 1971 from the specified territory, and B, has since the date of his entry into Assam been ordinarily resident in Assam, and C, has been detected to be a foreigner, shall, so detected, so these 3 conditions, actually there are 4 conditions, your Lordship may have noticed. It has to be first and foremost a person of Indian origin. Please note that. It has to be of Indian origin. It can't be, as defined, of course. Came to Assam on or after 1st January, that's and before 25th March. Third condition, has since the date of the entry into Assam been ordinarily resident in Assam. Again, a huge encouragement to remain on over there and make whatever type of claim that you want, and has been detected to be a foreigner. Fourth condition. Now, what is this person supposed to do? Shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority, hereinafter in this subsection referred to as the registering authority, as may be specified in such rules. And if the name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. Now see the explanation. In the case of every person seeking registration under the subsection, the opinion of the tribunal constituted under the Foreigners Tribunal's Order 64, holding such person to be a foreigner,
shall be deemed to be sufficient proof of the requirement under clause C of this subsection. And if any question arises as to whether such person complies with any other requirements under this subsection, the registering officer authority shall, 1. If such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. If such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order having jurisdiction in accordance with such rules as the central government may in this behalf under section 18 and decide the question in conformity with the opinion received on such reference. So now just pausing here and then I'll go to subsection 4. Our understanding of this submission is this. This is how it works. Number 1, all determinations, those 4 points which I mentioned, whether you are a person of Indian origin, came to Assam during these periods, have since been ordinarily resident and have been detected to be a foreigner. Everything is to be done by the tribunal alone. That's the first point I want to make. That's the determinant. The registering authority has to require an opinion of the tribunal. That's one. Second feature I want to point out is, for the purposes of registering, the detection exercise has to be first complete. You cannot seek registration without detection to be a foreigner or to be declared as a foreigner.
Third, there is no time on our understanding prescribed for this exercise at all, within which it is to be completed.
What is the second one?
Sorry.
What is the second one?
The detection by the tribunal of the foreigner is a condition precedent for applying for registration. You please just see, shall register himself. So it's an Indian origin, and then you have A, B, and C who has been detected to be a foreigner, then shall register himself in accordance with the rules, etc., made by the authority as may be specified. And you will find in 6A1B, the expression detected to be a foreigner is defined. It means detected to be a foreigner in accordance with the provisions of the Foreigners Act by a tribunal constituted under that order. So what you have is, and there's no time period prescribed for this. There's no time period at all which is prescribed for this particular exercise to be carried out. So no time period as far as 3 is concerned, no time period insofar as 4 is concerned. Now please see subsection 4. A person registered under subsection 3 shall have, as from the date on which he has been detected to be a foreigner. Please see the starting point for this. And till the expiry of period of 10 years from that date, the same rights and obligations as a citizen of India, including the right to obtain a passport and the obligations connected therewith, but shall not be entitled to have the name included in any electoral roll for any assembly or parliamentary constituency at any time before the expiry of the said period of 10 years. So this is post-detection. I'm sorry, this is detection and post-registration. Oh, it will be from detection. It will be from detection, my lord. Not registration, yeah.
4 is not conditional on registration. 4 is that you get the same rights.
Sorry,
4 does not postulate registration.
it does.
4.
Yeah, a person registered
Right.
under subsection 3. Correct? So first you will have to have a detection.
Once detection, registration under that section,
Then he applies for
then
registration.
he applies for registration. And then 4 says you will have the same rights and obligations.
No, but shall not be entitled to have included in the electoral roll for a period of 10 years, correct?
So for 10 years, they were knocked off the electoral rolls, basically.
But from what date is the question I ask myself? It's from the date of detection.
From the date of detection. Seems to be like that.
Yes.
Shall
I'll read it again. A person registered under subsection 3 shall have, as from the date on which he has been detected to be a foreigner, and till the expiry of period of 10 years from that date. So detection,
from the date of detected. Right.
correct. So no period prescribed for within what period the detection exercise has to be completed at all. Then from that detection exercise, 10 years. All rights except voting, and after 10 years, you will have a voting right. But this is completely open-ended, as your lordships have seen. It's an open-ended exercise. It can go on indefinitely.
It can be at any point of time.
It can, according to me, be done today as well. It can be done today as well. And people will continue to assert today. And it's bound to happen in that manner. Now, please see 5. A person registered under subsection 3 shall be deemed to be a citizen of India for all purposes, as from the date of expiry of a period of 10 years from the date on which he has been detected to be a foreigner.
So this is again open-ended. 6 and 7, those are narrow exceptions. I don't believe those really are particularly relevant to us. I'll place 8 though. 8. Save as otherwise expressly provided in this section. The provisions of this section shall, sorry. I just was placing subsection 8, which gives overriding effect.
Overriding effect.
Yes. Save as otherwise expressly provided in this section. The provisions of this section.
Just out of curiosity, I want to know, what is the position of the children born?
So I'll tell you my
Go by
position.
this.
So I'll just give you my
Used to
position.
be
But
The
it-
legislature where like putting the cart before the horse. It's on the reversal side.
no, I understand.
So I want to just respond by giving you what our position is, though that might be itself the subject matter of a separate exercise which has to take place. So as your lordships have seen that there is a notion of citizenship by birth, correct? Our understanding is, and even insofar as the manner of registration is concerned, as far as NRC process is concerned, if you are born to illegal immigrants, according to us, it is implicit that you cannot be registered or placed on the register of citizens. That's my respectful submission. That's my understanding of the law, and this will apply across the country. So there is a certain text, and there is a context also in terms of, you will find in section 3 of citizenship by birth. But our submission or our position, I shouldn't say my submission because I don't want to get into that separate section.
Actually, see section 3 because.
Oh, I understand.
Yeah.
So section 3, that is going to be a matter of interpretation and construction which will take place. And at an appropriate stage, the authorities at this point.
3 postulates that, on or after any person, every person born in India, will say takes clause C.
Yeah.
On after 2003 Amendment Act,
Yeah.
both of his parents are citizens of India,
Yeah.
or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of the birth.
Yeah.
So if one of the parents is an illegal migrant at the time of the birth, then you don't get the benefit of citizenship by birth.
Yeah.
Well, that will be a whole separate Thicketo point. But since the question is being put to me, I'm just indicating that from what we understand, as far as on the ground is concerned. Sorry.
We are only seeing the impact.
Yes, the impact. The impact.
Now, those who come in
Yeah.
before 1166
Who's
and
to
thereafter
determine that?
66 to 71, see, the grievance appears to be practically, if you see, with the generation who would have stationed here thereafter.
Yeah.
See, if let us assume that they come in their early teens,
Right.
they must be in their 70s or late 80s.
Right.
But what is the fallout of it? What is the consequence of it? That's what we have to see now.
No, of course. So the consequence, so there could be many consequences. The government is fully empowered. Sorry.
Interpretation under section 3 also will have to be given.
Actually, for section 3, the parliament has divided it into 3 time frames. Anybody who is born in India after 1950, after 26 January 1950, but before 1 July 1987, you become a citizen by birth, irrespective of parental status. Whether parents are citizens.
That's all. That's all, Your Honor. I understand.
Between 87 and 2003, any one parent, if he is a citizen, the child becomes a citizen, if you are born in India. After 2003, it is more stringent. Either both your parents have to be a citizen, or one person is a citizen, but the other should not be an illegal migrant. So they have tightened it up. Before 1987, it was nothing. I mean, irrespective
No,
of
but
parental
that's
status, you became it
probably
by-
on a textual, probably on first blush, your lordships may come to that conclusion. But in our respectful submission, because I don't want to get into that, there's a whole thicket of rules, etc., which they have framed, and there's a process and a protocol being followed for the purpose of
that doesn't
NRC.
fall for our determination.
I don't believe it is just because according to us it's implicit that where you have a situation where you have illegal migrants, they are to be prosecuted. There are a whole range of options which are available to the government as to what they can do if there is a breach and violation of the Passports Act, if people have entered, overstayed, etc., come in without appropriate documents. The whole range of responses which they may have. They may require you to be in a particular area. We're not getting into that. So therefore, I just responded very broadly. Our understanding is there's no automatic citizenship which is allowed insofar as children of illegal migrants are concerned. But that's a position. I don't want to go any further than that. Now, my lords, I want to just summarize. There is some separate repetition, I understand, etc. on that one. Anyway, so now I want to just summarize 3 or 4 impacts. So what are the impacts of 6A as we understand it? So I'll just summarize it. So one, according to us, illegal migrants in Assam
who are required to be identified and processed under Section 3 of the Foreigners Act 46 are rewarded with citizenship. This is one element.
Just 1 second.
So illegal migrants who ordinarily should have been identified and processed in terms of Section 3 of the Foreigners Act 1946, they are rewarded with citizenship. That's my first point. So far as prior to 1166 is concerned, there is no scrutiny envisaged at all. Next point, insofar as 6A2 is concerned, it is with respect to persons of Indian origin. There is no machinery under 6A2 for making such a determination. My next point is that illegal migrants are encouraged to remain ordinarily resident in Assam. Since this would entitle them to claim citizenship in terms of 6A3B. So you are required to be, since the date of entry has been ordinarily resident in Assam. So just imagine, if there's no time frame which is provided, you're going to continue to remain ordinary resident in Assam. This whole notion of ordinarily resident in Assam binds down the person to Assam, and it impinges upon all those other rights which I have already mentioned to the court. So this is, in our respectful submission, it nails the person down over there. It causes him and to remain over there, him or her. So this person just continues to linger and remain over here. He'll just, now the next point. Absent any time frame to complete the detection and registration, any time frame to complete detection and registration, these are separate, of course. Illegal migrants are incentivized to stay on in Assam in violation of law. And my final point is, the sequitur of ordinarily resident is people who have come are not even going to move elsewhere in the country. That's what I intended to convey. And the final point is that the very existence of Section 6A continuing on the statute book operates even today as a beacon to persons to migrate illegally into Assam. And then perhaps game the system in whatever manner they want and make a claim for citizenship. This is not there anywhere else in respect of any other part of the country. So it's open-ended. So even today, if somebody is, whatever, may happen, may not happen, as to where should I cross over the border from? This is a huge incentive, just as it stands on the statute book, because there's no time frame which is provided. Anyway, these are now having submitted this, I want to just give you two citations, just if I may.
They are on record. I'll give you the paragraphs as well. Now, what your lordships have held is that one has to examine ultimately the effect of the law.
What is the direct effect? And this test has been laid down in Bennett Coleman. So I'll just give you the citation, please. It is 1972, Volume 2 SEC, 788. It is at serial number 50 of Volume 5 from your index. Report begins at page 1563. And the relevant paragraph in this regard is paragraph 39.
1563, right? 1563.
1563 at 1587, para 39.
What volume is that?
Volume 5, Manoj. Serial number 50 of the index. And also in I.R. Coelho, Justice Sabharwal's judgment. I'll just give you again the citation. 2007, Volume 2, SCC, page 1. In the index of Volume 5, it is at serial number 132. Report begins at page 7586. And the relevant paragraph, that concluding paragraph of Justice Sabharwal is paragraph 150 of the report.
Page?
I'll just give that to you. It's at 7696.
Well settled, actually.
I think it's well settled. So when you're looking at the...
You don't look at the object of the law, but
yeah, exactly, to say X. Yeah, absolutely. So that I have. Now, Malaj, I'm on Article 14. So I'll just make my points on Article 14. So my first point is, I endeavor to attack the classification itself. So that's the first point. So my respectful submission, the classification
Is not based on any rational criteria.
And here I make 2 points. Assam is singled out here. But there is a severe problem, not just in Assam, but also in respect of other border states. With respect to illegal migrants from Bangladesh, including inter alia, West Bengal, Meghalaya, Tripura, etc. I go further and submit on the basis of the materials which I have already read yesterday, that there are other non-border states also. So 2 of them which were mentioned, for example, was Maharashtra was mentioned, Rajasthan, NCT of Delhi, you also may recall from those studies, etc., where this problem is there. So my submission is, first, Assam and the other immediate
Neighboring border states form a single homogeneous class.
My second alternative submission is that surely all the states affected by illegal migrants, whether at the border or elsewhere, for example, Bihar also has a huge problem, etc., face, West Bengal has a huge problem, form a single homogeneous class.
And to single out Assam, in our respectful submission,
Is impermissible. Particularly having regard to the enormous adverse consequences on the community and on individuals as far as Assam is concerned. So this is one part of my Article 14 submission. The next point which we wish to make is a violent or indeed any type of political agitation resulting in a political settlement is not a sufficient basis for classification.
Just repeat it. Mr.
Yes.
Siva.
Plus, I would respectfully submit that, look, nobody has disputed the fact that there was a political settlement. So there was the Assam Accord, correct? That, in our respectful submission, is not a sufficient rational basis for the present classification, which is singling out and isolating Assam.
for the purposes of your political accord, if the problem was in Assam, yes, you have an accord, you have an Assam Accord. But when you are making the law has to be something which follows which meets the constitutional test. That's essentially it. So this by itself can't be in the facts of our case and having regard to the impacts which are going to.
Mr. Devan, if your arguments would be still the same,
Yes.
if the benefit of Section 6A were to be given in all the other border states affected by illegal immigration,
Yeah.
suppose they were to extend 6A,
Yeah.
not just to Assam,
Yeah.
but if 6A were to apply to, say, West Bengal, to
Yeah.
Tripura,
Yes. Then
Then
this
it will get-
part of my argument may not be
not
available.
be there.
Sorry.
Then you're right. It may not
I may have other arguments, but not this one. I mean, I am trying to go. I am trying to present a case on all 3 footings. Number
The reason
one,
I asked you
classification.
this is-
Sorry.
The reason I asked you this is that 6A is a beneficial provision.
But
right?
for whom?
Obviously for a group of persons, it's a
No, but
beneficial
beneficial
provision.
has to be for citizens, Manoj. That's the point.
But therefore I asked you, was Parliament bound to make that beneficial provision for all persons similarly circumstanced in order for it to be valid?
No, I am.
Or can Parliament not say that in the interest of maintaining peace in a state which was riven by strife,
Yeah.
we have arrived at, obviously every compromise
Yeah,
is
we
never,
have a compromise.
never perfect. It
Yeah.
is never a perfect compromise.
Right.
But can Parliament say that to bring about peace in a strife-ridden state,
Right.
or should we continue that strife merely because we will be discriminating between states? Because these are sometimes very vexed issues.
So they are. I agree.
Or at that point, we have to put ourselves in the position in which the then government of India was in 1985. The then Parliament was in 1985.
Yeah.
The situation of Assam, where there was so much of violence at that time.
Right.
So any solution which they were finding is bound to be an inexact solution. You cannot have a mathematical solution in these cases.
But the issue, we don't need to be
So
trouble
suppose,
ourselves.
let me ask you, suppose they had given 6A generally.
Yeah.
Suppose they had said 6A will apply to any state.
Yes.
Any person coming
But
to
then the impact would not have been on me. You see, this person ordinary resident in Assam, right, which nails people down over there, which encourages people over there.
that point you made.
Well, I meant, so therefore, your lordship is right that if it had been an across the board dilution or whatever, 6A was applied across the country, then many of these arguments may not have survived. Your lordship is correct. I concede that. But that doesn't mean that however noble your cause might be or whatever your objective at that point of time, you have to do it in some manner which is constitutionally sustainable and which doesn't have an impact on one set of communities which are in one state.
All right. So,
And
that's
so anyway, I've made
that's
that
the
point.
second type.
Yeah.
That any
Now-
type
now,
of
so-
political
sorry.
agitation, any type of political agitation resulting in a political settlement
Yeah.
is not a valid basis for the present.
Yeah, solely, yeah, it can't be just held up that, look, we had this, it will have to pass various constitutional tests. Now, singling out, now, the next aspect is that rewarding illegal migration in one part of India, that is the state of Assam,
That is into the state of Assam. This is a separate point. Is and by itself a discriminatory object. So what your lordships have held is that, look, you may have a very clear classification. Your classification may be linked to the object which you want to receive. But if the object itself is discriminatory, then the law falls foul of Article 14. So here we have that 7-judge bench in Nagpur Improvement Trust.
Just one second.
Sorry, may I continue?
Yes, yes.
So may I just state the point and then the point is that I'll read from the 7-judge bench in Nagpur Improvement Trust, just one passage, and then I'll give your lordship the citation. The law recognizes that you may have certain situations where your classification is clear. It may have a reasonable or a rational nexus to the object which is sought to be achieved. But if your object itself is discriminatory,
then the law will fall foul of Article 14. Now, I'll just read that passage and I'll explain why the object itself is discriminatory in my case. So the passage, sorry.
If we formulate it like that, if the law in itself is discriminatory,
If the object of the law,
if the object
if
of
the object and effect of the law is itself discriminatory,
then merely because your classification is on intelligible differentia and it has a rational relation with your object, it would not save the law. So I'm now just reading one passage from Nagpur Improvement Trust, which is the 7-judge bench judgment versus Vittal Rao. I'll give you the citation, but I'll read the passage. It's para 26. It is now well settled that the state can make a reasonable classification for the purpose of legislation. It is equally well settled that the classification, in order to be reasonable, must satisfy two tests. One, the classification must be founded on intelligible differentia, and two, the differentia must have a rational relation with the object sought to be achieved by the legislation in question. In this connection, it must be borne in mind
that the object itself should be lawful. The object itself cannot be discriminatory. Or otherwise, for instance, if the object is to discriminate against one section of the minority, the discrimination cannot be justified on the ground that there is a reasonable classification because it has a rational relation to the object sought to be achieved. Now, this is your Lordship's language, so I'll just give the citation and then I'll link it up to our facts. So the citation is Nagpur Improvement Trust. It is 1973, 1 SCC, page 50.
It's a 7-judge bench of our court. It is at serial number 52 of the index in volume 5. It begins at page 1644. And the relevant paragraph is paragraph 26, which is at page 1650. And this judgment, I might just indicate, is followed in Subramaniam Swamy versus CBI, which is a 5-judge bench, 2014, 8 SCC, page 682. 2014, volume 8, Supreme Court cases 682. Yes, at serial number 154 of volume 5 in the index. And the report itself begins at page 9323. Relevant paragraphs being paras 44, 9359, 58 at 9366 and 68 at 9371. Now just let me explain in a moment as to what would happen to an illegal immigrant outside of Assam. So just let me summarize that very briefly. Appropriate orders can be passed for arrest and detention under section 3(2)(g) of the Foreigners Act 1946.
1 second.
So there's section 3(2)(g) of the Foreigners Act 1946. And the government can pass appropriate orders for arrest and detention of a foreigner who has entered without proper documentation.
Diwan under which section?
3(2)(g) of Foreigners Act 1946. Another, I'm not giving you an exhaustive list, but I'm just giving you 3. Another action against an illegal immigrant outside of Assam could be that the government can remove or deport the person who has entered without a passport under section 5 of the Passport Entry into India Act 1920. And there is a criminal prosecution the person would be exposed to, including imprisonment up to 5 years under Rule 6 and Rule 3 of the Passport Entry into India Rules 1950, read with Section 3, is it?
3
Of the 1920 Passports Entry into India Act. So the submission is that how do you draw out, I mean, the illegal immigrants are a single class in our, in a sense. And this particular category of illegal immigrants, you confer citizenship, etc. on. Otherwise, these persons would have all been visited with these penalties. Then I just want to indicate that perhaps this provision also suffers from the vice of being palpably arbitrary.
and I'll indicate why. You see, just consider a situation. You have two persons who cross over the border without their documentation, etc.
One lands in Assam, the other lands 50 yards away in one of the neighboring states, say Meghalaya or something like that. The question is that, is this not palpably arbitrary that a person who chooses an Assam route receives these type of benefits? With all the points which I mentioned regarding remaining there because you have to be ordinary resident and you continue to remain there.
And no time period within which you have to register, no time period within which a determination is to be made.
So we would respectfully submit that this results in palpable arbitrariness. And the Assam Accord, Manoj, your lordship is right. I mean, at that particular point of time, yes, of course. I'm not, why a political accord, there's no embargo against it. So no problem with that at all. But then when you're translating it into a law, having regard to the promises, such promises as you may have made, when you're translating it into a law, it must, in our respectful submission, meet these various tests, including Article 14.
Because Mr. Dewan,
Sorry.
we must actually also give the government that latitude. Even
Yeah.
today there are parts of the Northeast which we know. I mean, we need not name the states, but there are states which are, affected by insurgency,
Yes, yes.
which are affected by violence.
Yeah.
So, I mean, we have to give the government that leeway, even today, to make the sort of adjustments which are necessary to save the nation. Maybe 25 years later, it may appear, well, why did you make this concession when the nation is stable? But at that moment, sometimes these are compromises which the government has to make to save the overall, save the overall well-being of the nation. That is.
No, so that is I mean, I think that's a very sound rationale for entering, possibly for justifying the Assam Accord. I mean, I am not for a moment. We are not assailing the Assam Accord. The Assam Accord may be perfectly kosher, and there may be perfect justification for that. After that, the question is 6A and the manner in which you have coined and drafted 6A.
That you have made.
But I think the latitude, I appreciate, the latitude, always, the legislature has latitude.
Beyond that latitude because of the 14 violation.
Yeah. Now, I want to go into
point
one
that
other
we have to
aspect.
hear.
And your lordships may put it, because at least we've done as much of research, because these volumes are also volumes. There doesn't seem to be any, this is, I think, important for this kind of a statutory provision which you insert. There doesn't appear to be any study, because that was your lordship's question, or any material with the government at that point of time, by which they knew what the impact of this particular statutory provision is going to be. So when you're testing the provision now, all right, you can test it at that particular point of time. But you keep these open-ended provisions, which I'm not going to repeat. You keep them open for all time. You can come and register whenever you like. You can come and make a claim, and people will just linger on. Having regard to all of that.
That point you're very
Yes, having regard to all of that, Manoj, in our respectful submission, no study, no material estimates, Manoj. Some estimates that, look, these are the number of people who we feel will benefit from this 1st January 66 deadline. The second is, these are the number who will benefit between 66 and 71. There is no such material that at least we have been that we have seen. Yeah. Oh, sorry. Second. No, just two, I'll just state the points. Two aspects with regard to Article 14, which remain. Please consider also the principle of unequals being treated equally and being violated. Here, full-fledged citizens, on the one hand, illegal migrants on the other hand. And illegal migrants are being, who are according to us, completely unequal. They are unequal in the eye of the law for the rest of the country. And they are being treated here by this impugned provision as equal to citizens. So that I would respectfully submit fails the Article 14 test as well, or at least one dimension of it. We also believe in conclusion on Article 14 that we have discharged our primary burden and now it's really for the state to defend. Now I come to Article 21. I'll go very rapidly with your permission because I've already stated the essential elements. So in Article 21, I want to simply emphasize 3 or 4 aspects and you may then consider it because it's very widely interpreted. Please consider the community rights dimension of Article 21. Apart from my cultural rights, living in a community, ensuring that your community is not disrupted, that your community is not marginalized, that your community itself is able to continue to interact, hold its land. These are very important facets of 21. Please keep that in mind. The second element of 21, Mallards, I'm for a moment keeping aside rights with respect to voting, etc. But just think of self-governance aspects. Self-governance is also, according to us, a facet of 21. It's elsewhere in the Constitution as well. And here what we find is that apart from community, this whole element of self-governance within a region, within a village, within a town is being severely compromised as a direct impact and effect. And we have those studies which we referred to yesterday. The third element of 21 is meeting aspirations, economic, social, and political. And by allowing this type of huge illegal immigrant regularization, with potentially future generations also making a claim, without any time frame, it severely undermines economic, social, and political aspirations, which are facets of Article 21. And finally, the Lordships will also consider the impact of the destructive or the negative impact, I will describe it as a negative impact, on future generations of Indian citizens in Assam belonging to the communities who are here as petitioners before the court. Lordships have already noted the Sonowal case. Would your Lordship like me to just give the place where that is mentioned? I'll just give you where it is located in the paper book. So the Sonowal first case, 2005, volume 5, SCC 665.
2005.
5 SCC 665. You will find it at serial number 122 in the index of volume 5. Report itself begins at page 7047. Sorry, serial number 122, volume 5, page 7047.
At para.
And the relevant paragraphs, there's lots to read, but 62, 63 at 7095. In the context of Article 355, correct? So that I have made the point. Now again, I will just make points as far as Article 29 is concerned. I'm endeavoring to link this up to the studies which were placed before this court yesterday on cultural rights, language and script. Your Lordship saw those statistics and the dilutions, etc. And according to us, 6A operates to severely abridge Article 29. This type of abridgment of cultural rights, language, script, etc., falls foul of part 3. Now, may I just take you to the next point, where again, I wonder whether your lordships now have volume 5B. We gave it yesterday. It was that new. If your lordships have 5B, or we have the physical also. If you
No, we have it. No,
Right. So here I want to just, I'll just state the point, and then the fraternity I've indicated to your lordships is a value, a high value, which is mentioned and recorded in our, in the preamble itself. We understand it as being fraternity among citizens. And finally, I have made the point that this fraternity is used in the context of the integrity of India and the unity of India. Your lordship recalls that.
Yes.
Now, we have the advantage of three judgments of our court, so including a constitution bench. So please just, if your lordships would go to the constitution bench judgment, we are now concerned with volume 5B. The name of the case is Raghunath Rao versus Ganpat Rao. Raghunath Rao, Ganpat Rao versus Union. It's a constitution bench reported at 1994, Sup 1 SCC 191. And it's at serial number 3, index serial number 3 of this volume 5B. There are two relevant paragraphs. Page will be 79. The two paragraphs I wish to place are paras 109 and 111. At pages 111 and 112.
Raghunath Rao was the case where they said, after it was cited in 370 judgment, 370 hearings, which was post Madhura Sindhya, because Madhura Sindhya struck down the abolition of privy purses on the ground that you could not, by an executive act, de-recognize the ruler. After that, they introduced a constitutional amendment. Once the constitutional amendment came, they upheld the constitutional amendment because on the ground that the absence of a law, and you couldn't have done something contrary to the constitution, was then substituted by a legislation which operated to abrogate the privy purses.
The definition.
366, the definition of ruler, yes.
So it's in that context where...
This is L.M. Sharma's judgment.
Yes. Just, the one I am relying upon is Justice Pandyan's judgment.
Just Pandyan's judgment.
But your lordship is right, Justice L.M. Sharma, Chief Justice, presided over this bench. So may I just place those two paragraphs, because there's some discussion. I'll just read. They are page 111, 112. I'll read them. After carefully going through the above discussion, which relates to service matters, we are afraid that such an argument, as one made by Mr. Nariman, could be substantiated on the principles laid down in those two decisions that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for the word fraternity, explaining that fraternity means a sense of common brotherhood of all Indians. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that the unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first, irrespective of other bases. In this view, any measure of bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that the abolition of privy purses is not violative of Article 14. It is unnecessary for us to deal with the case cited by Mr. Nariman, which, according to him, go to say that any law violating 14 is equally violative of the basic structure of the Constitution, inasmuch as Article 14 is held to be a basic postulate of the Constitution. And then para 111, as repeatedly pointed out supra, The only question is whether there is any change in the basic structure of the Constitution by deletions of Article 291, 362 and the insertion of Article 363A and amendment of Clause 22 of Article 366. We have already answered the question in the negative, observing that the basic structure or essential features of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises on ifs and buts and arrive at a conclusion that Articles 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious, and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put to an end so as to have a common brotherhood. So this is the context in which they mentioned fraternity. But clearly, it is fraternity among citizens, and therefore, in our respectful submission, and the other two decisions which are in the same volume are Prithvi Raj Chauhan, which is versus Union. That, Your Lordships, there's a detailed discussion of Justice Ravindra Bhatt, and I'll just give you the paragraphs. It's a 3-judge bench judgment. It is 2020 for SCC, page 727. It's at serial number 2 of volume 5B. And the relevant paragraphs are 15 to 18, 21 and 34. Justice Bhatt actually goes and explores this whole notion of fraternity. He traces it down to how it was introduced by Dr. Ambedkar, etc. So that may be of some assistance to the court. Correct. So, Manoj, these are then my submissions. And there's a third decision of Nandini Sundar. It's in the same compilation, where again, Your Lordships will recall that there was an enlistment of certain persons, citizens against citizens.
Salva Judum.
And there the court said that no, pinning part of its reasoning on the element of fraternity and recognizing we can't really turn one against the other. So just please keep that in mind as well. So that is a 2-judge bench decision, 2011, 7 SCC 547. Yes. There is a passage here, my lords, which says that political expediency, you can, as Your Lordship rightly said, Salva Judum. So you can, there may be some reason for or justification, but that in itself, political expediency is no justification for in terms of enacting a valid law. Then, my lords, on 326 and 327, I've made my submission when I read the provisions regarding dilution of voting rights. And Your Lordships have seen that impact again in terms of the material which we placed yesterday. Now, as far as my submission on legislative competence, this will be developed more fully by Mr. Chowdhury, etc. But I'll just state the point. So, Your Lordship were quick to point to us that, look, this is citizenship is certainly mentioned in so far as Schedule 1 is, 7th Schedule is concerned, List 1. We are on another aspect. And the aspect that I want to just pinpoint is that the date given in the Constitution and which remains till this day for an automatic recognition of citizenship for migrants from Pakistan remains in the Constitution as 9th July 1948. Sorry, 19th. Oh. 19th, my mistake, Manoj. It's 19th July 1948. So until that provision stands in the Constitution as it does till this date, one cannot have a legislation which runs contrary to an extant constitutional provision. Now, with regard to the points on basic structure, which we have amplified in our written submissions, etc., I'll again just state the point. 3 values which according to us are central to basic structure: democracy, federalism, and rule of law, stand undermined. Your Lordships have now held that while ordinarily the basic structure doctrine is invoked for the purposes of challenging a constitutional amendment, it would also inform Your Lordship's decision-making process in the context of, say, manifest arbitrariness or certain other infirmities. these, my lords, values in our respectful submission 6A undermines these. I've explained it. I mean, your lordships will take it that it's in the context of the material which we placed on record yesterday. Now, my lord, so I now conclude on two aspects. One aspect is, I believe, I mean, my primary case is that as far, so I will make my short submissions on what ought to happen. So first, in our respectful submission, 6A ought to be declared. I think it's vital that this court declares 6A as unconstitutional if you are persuaded eventually to do so. According to us, it really can't stand any constitutional scrutiny at all. That's one. However, what is to be done thereafter should 6A be struck down? Because obviously there will be a number of people involved. So we would respectfully submit that the course which would be open for the government are several. And those are the ones which apply with regard to illegal migrants outside Assam. So you could have directions which are passed in terms of a scheme that you must locate yourselves at places A, B, and C. That's one possibility. This is where you have to confine yourself. That sort of dovetails in with that other alternative submission which I'm also going to make.
So in the second submission, what is the course open to the government that...
No, so what would happen, supposing these were illegal migrants are detected?
Deported.
No, so that's one avenue, which is, you're absolutely right. There is a deportation machinery which is available, but there are also other powers which are available to the government which require that a person who's identified as an illegal migrant go and restrict his movements or place the person at a particular location. So this is, my lord, sorry. There are several persons, my lords. There are, for example, your lordship recalls that passage from Justice Nariman's judgment, which says that as far as refugee law is concerned in our country, we're dealing with it at an administrative level. The reference order, which came up over here. So you have situations where certain communities, if they are found to be, say, refugees or are recognized as having come, but they haven't come with the appropriate passports and appropriate documentation, then they may be required to remain at X place or Y place. So you can frame a complete scheme with respect to these, but it ought to be something less than citizenship. One. And number two, it ought to be a scheme that cannot visit the consequences of illegal migration only on the population of Assam and the people of Assam and the communities of Assam. This is, if it is to be held as invalid, relief may be molded in this manner. These are suggestions. The government may have others. The other aspect which I want to mention, but certainly according to, if we are right, it ought to be less than citizenship. Now, supposing we are wrong and we are unable to persuade your lordships to issue the declaration we seek, even so, in our respectful submission, having regard to the enormous impact this has and the manner in which 6A works, by which you have to remain ordinarily resident over there, I believe there is an obligation on the union government to ensure that the full impact, now this feeds into the observation made by the Chief Justice, but look, if you have to preserve the integrity of India, all right, if that eventually argument appeals to the court, I don't believe it should, then surely you can't just have one set of districts on a border of one state which takes and those communities which take the entire brunt. Then the national interest has to be dispersed in some manner by which the impact is not on me alone. Me as in the petitioners before the court. So you have to come up with a scheme nevertheless. Even if we are wrong, they will have or ought to be a set of directions so that we are not visited in perpetuity and for generations to come with these type of impacts. And some states, I must say, some states on affidavit have recognized this problem. Maybe they have problems themselves, but they have said that yes, if there are issues and directions, we realize that Assam has a problem. we will, of course, extend our full cooperation. I'm very grateful.
Thank you, Mr. Diwan. Thank you. You really kept your time. We had given
But
you
I,
1.5
but I,
hours.
Manoj, I don't,
You started at 5 to 11 and to the dot you finished at 12:25. Thank you very much.
I don't have a brief for my learned friends, but Manoj, I don't think, having regard to the scope of this case, they should. I mean, I was, as a first batsman who didn't get out within the first 5 minutes or first 5 balls, I was able to continue. But I think this will require an exposition on their part, which may take more than the time which your lordships had initially contemplated. I'm very grateful. Thank you.
May it please your lordships.
Mr. Chaudhary, which petition are you appearing in?
I am appearing in WPC 562 of 2012, my lord.
560?
562 of 2012.
Item number?
And broadly, which is the ground which you are covering now, Mr. Chaudhary?
Actually, my lord, I'll adopt the argument which my esteemed colleague Mr. Shyam Devan has done, but I'll supplement the argument on all the points, my lord. But you will kindly give me that liberty.
So long as you are not repeating anything which
No,
Mr.
I'll
Diwan
not
has
repeat
covered.
a single argument. I'll not
Yeah.
even repeat the facts which my learned friend has
Yeah.
referred. I'll of course refer to some facts which my learned friend has not referred, and
Yeah.
which we consider it's, my lord, relevant for the adjudication of the case.
Yes.
My lord, the first aspect which I would like to highlight is, my lord, the reference order itself recognizes what we have said, my lord. Of course, to a due deference to be extended by your lordship's bench. My lord, the reference bench has taken note of the fact that entire people of the state, including the tribal people, are before the court, and they're expressing a grievance which has got legitimacy, my lord. Now, therefore, our duty is to satisfy your lordships that this legislation in the form of Section 6A was wholly misconceived, my lord. My lord, can we conceive of a situation? The government of India wants to protect the immigrants at the cost of the indigenous people of the state. Can this be an object, my lord? My friend Mr. Diwan has referred to the judgment, my lord, we said that 1973, my lord, that just now he has referred to the judgment,
Yes, yes.
Nagpur Improvement Trust.
Where the object itself is discriminated.
Yes. Now, my lord will kindly see, in Sonowal's case, the Honorable Supreme Court has went to the extent of, sorry, this Honorable Court has, we in the High Court, my lord, we are used to saying Honorable Supreme Court. So I forgot for a moment that I am in the Supreme Court, my lord. So, my lord, their lordships has said, my lord, that the object has to be lawful. My lord, where is the difficulty in, my lord, en masse deportation of aliens? Aliens at will. These are all aliens at will. My lord, there is a distinction between an illegal migrant and a foreigner. My lord, I'll satisfy your lordships why this legislation is bad, my lord. Now, kindly see, detected to be a foreigner is an expression which is defined in Section 6A.
Right.
Kindly see, my lord, this does not take note of the legislation called, my lord, Immigration Expulsion from Assam Act 1950. My lord, Assam had this problem even post-partition, my lord. Assam had the problem on the eve of the partition, post-partition, 65 war, 1971 war. My lord, we are saturated. Today, my lord, I may tell your lordships, out of 126 assembly constituencies, indigenous people can win election only in 57 constituencies. That is the state of affairs. My lord, yesterday, your lordships wanted to know what is the extent of immigration which has taken place between 1951 and 61. I'll give the figures. There are figures. In fact, it is the Prime Minister of India at the relevant point of time who made a statement in the Parliament. Those are replacement. So therefore, what I propose to do, my lord, my ground of challenge is, this is a legislation which was brought in by a regime who had a brute force of 400 plus MPs. This is a legislation not at all called for, my lord. It's, my lord, if a lordship kindly permits me, I would say it is a parliamentary joke to have such a legislation. Can you conceive, my lord, of a situation where a parliament has enacted a law instead of protecting the, my lord, the indigenous people or the people of the state or people of the country living in that part of the state, and, my lord, come to the rescue of these immigrants only for the sake of political expediency? My lord, I'll first refer to that article, my lord, where, my lord, these figures are given, that your lordships will get at page number 3224 of volume 4.
What is the page number, Mr. Chaudhary?
My lord,
Page number?
page number 3224 of volume 4. Your lordship's kind permission, can I have, sir? My lord, it's an article written in Oriental Times on July the 7th on 1999, my lord. I'll read the second subparagraph. In spite, as the lordships got it, in spite of these legal provisions, a steady flow of migrants from East Bengal to Assam continued unabated. So, with a view to stopping illegal infiltration, Parliament enacted on December 24, 1949, Immigration Expulsion from Assam Act 1950. In the statement of objection reasons of the bill, it was said that stay of such person or class of person is detrimental to the interest of the general public of India or any section thereof. The tribal people of Assam have been the major victim from the migration of infiltrators from East Bengal. Close on the heels of the bill being passed by the parliament, Pakistan started complaining, whereupon discussions followed between Pandit Jawaharlal Nehru, the Prime Minister of India, and Liaquat Ali Khan, the Prime Minister of Pakistan. On April the 6th, 1950, Nehru-Liaquat Pact was signed, which provided for return of East Pakistani Muslims. This was taken advantage of in full measure by the East Pakistani Muslims who had earlier been pushed back from Assam. The whole purpose of 1950 Act was defeated. Furthermore, the National Register of Citizens prepared in 1951, taking resort to the cover afforded by the Nehru-Liaquat Pact, included good citizen, those of East Pakistani Muslim, whom the Act of 50 described as foreign infiltrator, and directed their expansion, but could not be expelled due to the Nehru-Liaquat Pact. Nehru became a party to this pact mainly for two reasons. He wanted to show India was so secular that Muslims and other religious minorities preferred India to their countries of origin, ostensibly created on the basis of the religion. Secondly, the Congress party, of which Nehru was the parliamentary leader, had in the meantime struck an understanding with the Muslim religious leaders that Muslim community would be a solid and stable vote bank for the Congress party. Then, my lord, may kindly skip that, kindly to come to the subpara, starting with the 1961 census showed a 34.97% of increase of Assam's population against the national average of 21.64% in the decade 1951-61. The census of 61 estimated that not less than 750,000 East Pakistani Muslim infiltrated into Assam within the decade of 51 and 61. In 65, Prime Minister of India made a statement on the floor of the Lok Sabha to this effect on the basis of the report of the Indian Intelligence Service. Late B.P. Chalia, the then Chief Minister of Assam, however, estimated the influx at 3.5 lakhs only. However, 10 tribunals were set up to hear the appeals. They appealed the confirmed infiltrators. Therefore, in the year 1967, 68 and 69, 1.2 lakh infiltrators were expelled, deported from Assam. Thereupon, 33 Congress legislators belonging to Muslim community led by Mainul Haq Chaudhary, Devakan Borua, Sarath Chandra Sinha demonstrated against the Chief Minister and said, if all expulsions of the alleged Muslim infiltrators be not stopped forthwith, Muslim bloc of Congress vote would be lost forever. Now it is in any case lost. The liberation struggle of East Pakistan and formation of Bangladesh state resulted in increased infiltration of Muslims from that region to Assam. Sheikh Mujibur Rahman openly said that Assam was the natural field for expansion of Bangladesh. During the period from March 25, 1971 to December 12, 1971, it is on record that more than 12 lakh people came over to Assam from East Pakistan and took shelter here with their relatives, friends, acquaintances who had come over earlier. Most of them did not return. Now, this is very important. The Ministry of Home Affairs, Government of India, via memo dated September 30, 1972, informed the Government of Assam that Indira Gandhi, Prime Minister of India, had arrived at an understanding with the Prime Minister of Bangladesh, Sheikh Mujibur Rahman, to the effect that such person as has come over to India from erstwhile East Pakistan before March 25, 1971, shall not be deported. In case of person who had illegally entered India after March 25, 1971, the state government should prepare a list and forward the same to the branch secretariat, External Affairs, Government of India at Calcutta. In duplicate, which should they submit a list to the Deputy High Commissioner Bangladesh at Calcutta to liaise with him for a deportation, but no such deportation took place. In substance, this amounted to the proposition that Article 5 and 6 of the Constitution of India would have no relevance to regard to the infiltration. Such Bangladeshi infiltrators to Assam became thus well protected. So, my lord, this is the background. Now, my lord will kindly appreciate. Now, there was an understanding between the then Prime Minister of India and the then Prime Minister of Mujibur Rahman that people who illegally entered Assam prior to 25th of March 1971, they will not be deported. My lord, that agreement is not the basis of this act or the amendment. At least the statements of objections reasons do not disclose that. Now, ordinarily under the constitutional scheme, my lord, under
That agreement, was it recorded in writing, that agreement between the then Prime Minister of India?
We could not lay our hands to it. I think it exists. There's a friendship treaty where this proposition is not there, but it is widely acknowledged, my lord, that there was an agreement to that effect. That's why there is a memo of the Government of India, Ministry of Home Affairs. Now, my humble submission is, my lord, if you want to give effect to that treaty, assuming it's a treaty between the then government of Bangladesh and the then government of India, then, my lord, in terms of Article 253, there ought to be a parliamentary legislation. There is none. Therefore, this date, 25/3/71, loses all its significance. Assam Accord does not say 25/3/51, my lord. Assam Accord is a political settlement, my lord. Now, can a political settlement be the basis of an agreement? My lord, for a moment, we are not questioning the competence of the Union of India to make the amendment. But the question is, we're concerned with the subject matter. It's not the source of the power. There could be a source of power. Source of power is there. Article 11, read with Article 245, read with, my lord, entry 17, list 1. But the question is, what is the subject matter? Subject matter is acquisition of citizenship by a class of person who admittedly are illegal migrants. That is an aspect which needs your lordship's consideration, my lord. Now, question is, if you are an illegal migrant and for which an act was enacted way back in 1950, it was duty of the Government of India to stick to that act and, my lord, deport them. Instead of doing that, my lord, what they did, they came up with this amendment. My lord, I think the article which I have, my lord, shown reflects the political expediency involved in the entire scheme of things. It's a vote bank politics. It is not only perceived, it is, my lord, acknowledged. Now, therefore, my lord, Since there is no parliamentary legislation in terms of Article 253, since Assam Accord, which is the premise on which, my lord, the amendment, impugn amendment was carried out, does not speak of 25,371. Where from this date 25,371 has, my lord, followed? Has it fallen from the heaven? It couldn't have been. So, in the affidavit filed by the Government of India, other than a statement that foreign illegal migrants who came before 25,371 were not to be deported, they have not given any disclose any reason. What is the sacrosancy of this particular date 25,371? End of the day, Lordship is testing at the legitimacy of a parliamentary exercise. That too, my lord, where the own people have been rendered, my lord, minority in their own state. My lord, there are section of the citizens who cannot enjoy their pujas in the state of Assam. If we go to the old Gwalpara district, my lord, it is almost 90% plus immigrants. We can't even move, we cannot venture into those areas. How do we enjoy our right under Article 21? How do we enjoy our right under Article 29? My lord, government of the day must create a situation where the citizens can enjoy their cultural right. They need not spend money to develop our culture, but they have a duty, constitutional duty, to create an atmosphere where citizens can enjoy their cultural rights. Where are those, my lord? Now, my lord, I'll refer to 2-3 paragraphs from the Sonwal. Then I, my lord, refer to the legal submissions which I propose to make.
Just give us the paras.
Yes, my lord. One second. My lord, the Sonwal judgment starts at page number 7090. Sorry.
It's at 7047.
Yes, 7047.
Volume 5.
Yes. I'll have your lordship's kind attention to page number 7090, my lord, onwards.
Just give us the paras and tell us what it says, why
Yes.
you're relying on it.
Yes, no, my lord, there are one, para 70, I'll have to read, my lord.
Para
70. My lord, I'll rely upon paragraph 51, 52, 53, 56, 57, 63, 70, 73, 79, 80 and 83. But Lordship will kindly permit me to read this para 70, madam. Page 7100.
What does it say? You can
Yes.
just formulate it. You need not read the whole para. So you can just formulate it. What is
My
it?
lord, it speaks about the effect of the presence of this stream of illegal immigrants, where it says, my lord, Assamese people has been rendered minority in their own state, and it has set in, my lord, demographic profile change, irreversibly. If a lordship's, with a lordship's kind permission, may I read it?
Yes.
As mentioned earlier, para 70, at page number, my lord, 7100, influx of Bangladeshi nationals who illegally migrated into Assam pose a threat to the integrity and security of the northeastern region. Their presence has changed the demographic character of that region, and the local people of Assam have been reduced to a status of minority in certain districts. In such circumstances, if Parliament had enacted a legislation exclusively for the state of Assam, which was more stringent than the Foreigners Act, which is applicable to the rest of India, and also in the state of Assam, for identification of such person who migrated from territory of the present Bangladesh between 1166 and 24371, such a legislation would have passed the test of Article 14, as the differentiation so made would have had the rational national nexus with the avowed policy and objective of the Act. But the mere making of a geographical classification cannot be sustained, where the Act, instead of achieving the object of the legislation, defeats the very purpose for which the legislation has been made. As discussed earlier, the provisions of the Foreigners Act are far more effective in identification and deportation of foreigners who have illegally crossed the international border and have entered India without any authority of law and have no authority to continue to remain in India. For satisfying the test of Article 14, geographical factor alone in making the classification is not enough, but there must be nexus with the object sought to be achieved. Then, my lord, there is one more paragraph. If your lordship would kindly come to para 75, my lord, at 7102. Here, my lord, I'll deal with that aspect of, my lord, the scope of Foreigners Act and the Act of 1950. Now, International Covenant on Civil Rights, to which India is a signatory, my lord, Article 13 thereof mandates that a person who enters another country lawfully, he alone is entitled to the due process of law. A foreigner, an illegal migrant at will, he is not entitled to due process of law. My lord will kindly appreciate if this is the legal position. If the legal position is, my lord, in the international law as well as our Honorable Supreme Court has said, my lord, this Honorable Court has said that en masse deportation is a course which is open to the government of the day. What was the obligation? What was that compelling reason, my lord, why this legislation was made? My lord, this is very important, my lord. On one hand, you had the option of deporting them, which you did not do. Now, kindly appreciate, my lord, interpreting Article 355 of the Constitution of India, this Honorable Court, my lord, while upholding the Armed Forces Special Powers Act, had said that Article 355 enabled the making of a legislation like Armed Forces Special Powers Act. If that is the position, my lord, why, my lord, 355 should not be invoked in this case? Lord, therefore, I will submit, my lord, we are before lordships under Article 32, where this Honorable Court has said it is the duty of this Honorable Court to protect the interest of the citizens, my lord. We are before your lordships. Now, kindly see, my lord, in Sarvananda Sonwal, my lord, this aspect was taken note of at para 77. In Introduction to International Law by J.G. Stark, the law point has been stated thus: most states claim in legal theory to exclude all aliens at will, affirming that such unqualified right is an essential attribute of the sovereign government. The Court of Great Britain and the United States have laid it down that right to exclude aliens at will is an incident of territorial sovereignty. Unless bound by international treaty to the contrary, states are not subject to a duty under international law to admit aliens or any duty thereunder not to expel them. Nor does the international law impose any duty as to the period of stay and as admitted aliens. Like the power to refuse admission, this is regarded as an incident of the state's territorial sovereignty. International law does not prohibit the expulsion en masse of aliens. Reference has to be made to Article 13 of the International Covenant of 1966 on Civil and Political Right, which provides that an alien lawfully in the territory of a state party to the covenant may be expelled only pursuant to a decision reached by law, and except where compelling reasons of national security and otherwise required, is to be allowed to submit the reasons against his expulsion and to have his case reviewed by and to be represented for the purpose before competent authority. It is important to note that this covenant of 66 would apply provided an alien is lawfully in India, namely with valid passport, visa, and not otherwise who have entered illegally unlawfully. Similar view has been expressed in so-and-so versus so-and-so. The author has said that reception of alien is a matter of discretion, and every state, by reason of its territorial supremacy, competent to exclude aliens from the whole or any part of its territory in para so-and-so. It is said that right of states to expel alien is generally recognized. It matters not whether the alien is only on a temporary visit or has settled down for professional business or any other purpose in its territory. Having established his domicile there, a belligerent may consider it convenient to expel all hostile nationals residing or temporarily staying within its territory, although such a measure may be very harsh on individual aliens. It is generally accepted that such expulsion is justifiable. Having regard to Article 13 of the International Covenant on Civil and Political Rights, an alien lawfully in a state's territory may be expelled only in pursuance to a decision reached in accordance with law. So, my lord, there was no obligation on the part of the government of India even to admit them, my lord. I can appreciate, my lord, some people are seeking refugee status, though there is no legal regime of the country as yet, my lord. From time to time, by executive fiat, decisions are being taken. But question is, millions of people, my lord. My lord, under Part 2 of the Constitution, which is the premise on which the law on citizenship rests, does it conceive of a concept called deemed citizenship? It is only for political experience, nothing else, my lord. Possible certainly not give judicial imprimatur to such a legislation, my lord. It's a legislation which is on the face of it, my lord, expressly illegal, my lord. It's unconstitutional. Urged by my esteemed colleague, Mr. Diwan, my lord, it can't be saved from whatever angle we view at it, my lord. Yes, we are not for a moment questioning my lord, the power of the parliament to make the legislation. It is there. But question is, when you make a law, what is one more thing, my lord? When it comes to Article 14, of course, we'll say, my lord, there is no intelligible difference here, and the objects ought to be achieved has no rational, etc., etc. Is it also not a case of a protective discrimination, my lord? When you are making a classification qua a class of foreigners, that means you are extending a benefit of protective discrimination. If it is a case of protective discrimination, then, my lord, is the burden of the Union of India to satisfy your lordships with empirical data. Unlike in the other case where the burden is upon the citizen, my lord. Yes, there is a presumption in favor of the legislation. But the moment we discharge it, the burden shifts. In my humble submission, my lord, it's a case of protective discrimination. So you must have the data. Where are those data? My lord, in Jagadish Saran case, my lord, I'm sorry, my lord, the judgment is not a part of the compilation, where this honorable court has said, my lord, when it's a case of protective discrimination, then, my lord, the onus is on the state to discharge. With not only, it must not only be pleaded, it must be pleaded and it must be established. That's the language used. My lord, can I hand over that copy, my lord? Sorry, my lord, it's not the part of the compilation. Other side to deliver. Lord, will kindly come to para 34 at page 783, my lord. Thus, the constitutional principles and limitations are clear and the norms are belighted by the precedents. But their application to the specific situation is an exacting task. Burden when protective discrimination, promotional of equalization is pleaded, is on the party who seek to justify express deviation from equality. But Delhi University stated here, the learned Attorney General frankly admitted that student agitation without more could not validate reservation, and the excessive reservation was an obvious inequality. Nor indeed it is a good plea that illegal reservation is being practiced by other universities and the university is forced to act illegally in self-defense. Lawlessness under our own system is corrected by law, not by counter lawlessness. So it is strange for the Delhi University to say our disorderly behavior is orderly because other universities behave similarly. Once this misguided defense of direct action by students of reprisal against other universities are brushed aside, we come to the grip with the real issues. Is there circumstantial justification for constitutionalizing the reservation strategy, especially at 70% plus? Then my lord will kindly come to paragraph 37. Para 37, my lord. The argument urged in answer is that doors for admission to the postgraduate medical courses are almost completely closed for Delhi graduates by all other universities. So protective reservation becomes necessary as the only hope of Delhi students for postgraduate studies. Those real life factors will show that Delhi graduates are denied de facto equality on a national scale by exclusionism of other universities, and that therefore they deserve sheltered equal opportunity in actuality by barriers of reservation of a high percentage of seats. Such being the university's defense must be made out, not merely asserted. I am on this mind. So empirical data are required.
What is the next point now?
Yes. Now, my lord, if your lordship will kindly permit me, I would like to place the pleadings of the government of India on this, my lord.
What's the point that you're making?
Yes, point that I am making was, my lord, actually I was on facts. Incidentally, my lord, I made a submission regarding that protective discrimination. So that is how I refer to the judgment. I was basically referring to the factual aspects, my lord. First, I relied upon that article. Second, I relied upon my lord.
Don't treat it as facts. That's a, God knows what is the authenticity of that article. It's an article in some journal called Oriental Times. We don't know what the authenticity is.
No, my lord, with
We
all
didn't stop
respect.
you from reading, but it's not a primary source.
No, my lord, it refers to the statement made by the Prime Minister of India.
Sweeping
Very
statements
sweeping
also.
statements are
Sorry,
made in
my
that
lord.
article.
It can be verified, my lord, whether
You
it,
go to the internet, you will find plenty of invective on both sides.
Yes.
But we can't just rely on some article and, decide a constitutional
anyway,
case
my
on that basis.
anyway, my lord, since my lord, this appeared in the article, my lord, we place for your lordship's kind consideration. The lordship will take an appropriate view of the matter, my lord. We felt, my lord, it is of some relevance to
It's
the.
a point of view.
Yes. No, my lord, they are referring to facts. It's not a question of fact.
What facts? It's not footnoted. There's not a single footnote in the article. How do we know that they are facts? How are they even ascertainable?
Okay, my lord, we'll try to come up with some more authentic, materials to support those facts. By rejoinder, my lord, we'll place that, my lord.
Nothing new in rejoinder. Huh? Whatever
no.
is concluded.
No, I'm
now
not
is
speaking
concluded.
about-
Otherwise, they will have it will be
No,
unfair to them.
what I'm saying is, my lord, while giving our rejoinder argument, we'll try to have that by that time. I'm meaning that only.
But in rejoinder,
I'm not
no,
asking for any
no,
time to.
no, but no new material in rejoinder.
Okay.
Everything is concluded when you reply.
Yes.
There'll be no ambush in a rejoinder.
Okay. Yes. If your lordship will kindly come to my lord, volume 3.
Mr. Chaudhary, why don't you do this? We're about at 1 o'clock. You formulate your submissions now.
Yes.
So we've heard the matter almost for a day and a half. You can formulate your submission and then tell us briefly what under each head so that.
Yes, at 2 o'clock I'll do that, my lord.
So you.
Well, I'll just refer to two facts, my lord. One, a committee was constituted by the government of India post-Kargil war, my lord, where the committee was headed by the defense minister of the country. They made some recommendations, my lord, which includes, my lord, or rather deals with the insurgency and illegal immigrant issue of Northeast. I'll refer to that. Then I'll formulate my legal points.
All right.
And Mr. Chaudhary, in that article,
Yes.
there is a reference to this immigration expulsion from Assam Act 1950. That act must have defined who are the people who were treated as migrants or immigrants under that act. Is there any definition clause?
No.
And
No, my lord, under the 1950 Act, this was an,
Just find out during lunch
Okay.
time that what is defined there in that act.
okay.
And is it inconsistent or in conflict with what is defined or what can be inferred now from section 6A? The persons of Indian origin who were settled in Assam. Does the definition, does it in these two statutes, are they referring to the same set of persons or they are varying?
Okay, I'll look into it and get back to your lordships at 2 o'clock.
The Act itself is on the record of this case. It's in volume 4, page 424.
Yes, that's
It's a one-page act. And in fact, it makes an exemption. It's called the Expulsion from Assam Act. The act is specific to Assam and it enables the government to expel people from Assam, but it makes an exemption within the act for people who have come here on account of civil disturbance. So it doesn't confer citizenship on them. It certainly doesn't confer citizenship on them, but it provides for expulsion. But your lordship will find it at page 424. It's a mechanism under which there is a
It's a
provision for
It's a
expulsion.
1950 act, it must be referring to the
It is
disturbances
on
which were prior
record.
to
The
that.
1950 Act is on record.
I'll come to this aspect.
So there is a
pointed
kind
out by
of
learned friend.
tolerance, my lord. There is a kind of tolerance of people who come on account of civil disobedience in that act.
So, Mr. Chaudhary, now we'll give you about half an hour, 2 to 2:30.
No, I cannot lodge.
We are not making, oh, you will not make any headway for the next 5 days, but we are not going to give you 5 days.
Because we don't see you have made any headway in the last 35 minutes. You can't hijack the
No, I am not
proceedings for the
asking, my lord,
constitution.
initially, my lord,
You have to comply with the time schedule which I set for you.
no, lordship will kindly
We are
appreciate.
very clear. We did that. we did
Initial
that.
understanding
Mr.
was
Chaudhary,
one
Mr.
for-
Chaudhary, we did that in something as sensitive as Article 370. If you can't make a point in 30 minutes, you're not going to make it in 300 minutes. You have to make your point, make your formulations, and then we'll give you time. But half an hour and that's it. Thank you.
Okay, half an hour for formulation, that's great. Good, good.
Half an hour for concluding your arguments.
I think so.
May it please your lordship.
So,
Well,
Mr.
the
Chaudhary,
points-
if you can just formulate now
Yes,
your
yes,
point.
yes, I'm obliged. My lord, the first point is, which I have of course already argued, but the lordship may kindly take note of that. There was no compelling reasons for making that enactment.
That point you made in the morning.
Yes, it has got, my lord, two subpart. First subpart is Assam Accord being a political settlement, it could not have been the basis. And second part is, my lord, regarding the date of 25/3/71. There is no parliamentary legislation, assuming, my lord, there is an agreement between the prime ministers of the two countries, but there is no, parliamentary enactment ratifying that agreement as required under Article 253 of the Constitution of India. And the,
Just repeat the point.
my lord, first point was that Assam Accord.
That's fine.
Yes.
Next point.
Next point is, my lord. Next
No basis to adopt 25/3.
regarding the date, my lord. Sanctity of the date, my lord. No sanctity of the date, that is 25/3/71.
All right, that section,
Yes.
Yes.
that's the first point. Then,
The another part, limb of that point is, my lord, it is actuated by political expediency.
that you have made.
Yes.
You've said that.
Yes. Then second point is, my lord, Section 6A is violative of Part 2 of the Constitution of India. Here I'll elaborate a little bit, my lord.
Part 2. First, you can,
There I'll try to satisfy your lordships.
what is the third point?
Third point is, my lord, violative of Part 3 of the Constitution of India, including Article 13, my lord, because I'll submit that this is a stillborn legislation.
Why is it stillborn?
My lord, on the day the legislation came into being, IMDT Act was holding the field, which made detection of foreigner practically impossible. It was struck down by this honorable court only in May 2005. So from 85 to 2005, that is for 2 long decades, nothing moved, my lord. Not a single foreigner was detected.
All right, then fourth.
Yes. Fourth, my lord, Section 6A takes away the political right of the people of Assam, in as much as it is violative of 326 and 327.
That Mr. Diwan has already
Yes,
answered.
yes. I'll just place 2 judgments on that, my lord.
And?
And
That's it?
last but not the least, my lord, I'll deal with certain aspect of the Citizenship Act.
How
For
do you
example, my lord.
formulate.
Yes, a violation of section, the provision could not have been inserted because of section 5(2) of the act, because a person of undivided.
How you formulate? How do
Yeah,
you
formulation would be, my lord, the section 6A is ultra virus. The act itself,
How can
that is section 5(2).
how can a statutory
No.
provision be ultra vires the act?
No, my lord, why I'm
Or
saying.
subordinate legislation can be ultra vires the
It will
statute.
be ultra
A
virus the
statute can be ultra vires the
It will
constitution.
be ultra virus the enabling provision. That is the constitution.
Ultra vires what?
The constitution, my lord.
But that you have said, that in point number 3.
What I'm trying to,
Ultra vires which constitutional provision?
Article 11, my lord. By taking recourse to Article 11, this legislation could not have been framed.
All right. Is
Without-
ultra vires Article 11.
Yeah,
All right. that's right.
without variation of Article 6.
Huh?
Without,
Section 6 says ultra vires Article 6.
yes, my lord. Because without variation of Article 6,
No, you said Article 11, that's why.
yeah,
Article
11
6.
read with 6.
All right. All right. Now you covered the first point. Now tell us on the second point.
Yes.
How is it violative of Part 2?
Yes. Now, my lord will kindly have the constitution for a moment, my lord. Article 11. My lord, my friend Mr. Diwan has already referred to Article 6 to contend that as far as migration from Pakistan or present-day Bangladesh is concerned, my lord,
Yes.
there is a date already given in the Constitution, that is 19th of July 1948. Our submission is, my lord, without variation of Article 6, Section 6A could not have been enacted.
Without the variation of Article 6.
6. Because Article 6 provides a cutoff date, that is 19th of July 1948.
Now, my lord, if your lordships kindly comes to Article 11, nothing in the foregoing provisions of this part shall derogate from the power of the Parliament to make any provision with respect to acquisition and termination of citizenship.
But Article 6 is for migration from Pakistan.
No, my lord, this is my
A
lord.
date which is adopted by the Constitution for the purpose of migration from Pakistan,
Yes.
namely 19 July 1948.
In fact, my lord,
So not
Present-day
Say that
Bangladesh, any person who has migrated into India as of 19 July 1948 shall be deemed to be a citizen.
Yes. So what I am trying to submit for lordship's kind consideration is, my lord, present-day Bangladesh, the then East Pakistan, is a part of Pakistan.
Right.
Now, when the constitution was adopted on that day, my lord, this provision was there. Anybody who wants to migrate from Pakistan to India, there is a cutoff date. Now, it will definitely relate back to that date when Section 6A gives
So according
protection
to you, Bangladesh as a successor state.
successors.
Their citizens are also bound by the date of 19 July 1940.
Precisely.
All right, we got the point.
Yes, yes.
now, my lord, why I am making this submission? My lord, Article 6 is a constituent provision. Now, by exercising ordinary legislative power, Parliament cannot, my lord, tinker with the constituent provision. Now, in the Constitution, my lord, there are certain provisions where, without taking resort to Article 368, some provisions of the Constitution can be tinkered with.
And it has been expressly provided, for example, in the Article 2, Article 3, Article 4.2, Article 169.3, Article 239 capital A within bracket 2, Article 239 capital AA 7B, Article 243M, Sub-Article 4B, 243 2C3 and 244A4 proviso. So, my lord, wherever the constitution maker intended that any provision of the constitution can be tinkered with, it can be done without taking resort to 368.
These are the provisions. Now, my lord, by giving a day cutoff date which is different from what is given in Article 6.
Article 6 is violated.
Right.
All right, we'll hear the other side because you have made the point.
Yes.
You didn't labor the point.
Yes.
So that covers your point number 2.
Yes.
Now the point number 3.
Then, my lord, regarding Article 11, my point is, Article 11 does not start with a non-obstante clause. On the contrary, my lord, it starts with the expression, nothing in the foregoing provision of this part. My lord, Article 11 vis-a-vis Article 6 has never failed for consideration of this Honorable Court. This is the first time, my lord, that issue is being raised. There are judgments on Article 11 vis-a-vis Article 9. That is
What is nothing in the foregoing provisions of this part? What is it but a non-obstante clause?
My lord, my question is,
And
We are concerned with constitution vis-a-vis a parliamentary legislature. And
my lord,
you can't say it's not, non-obstante clause will not come there.
my lord, with utmost respect, I'll submit, my lord. In my humble understanding, subject to lordships may say, the meaning is, my lord, by invoking Article 11, certainly power vests in the Parliament to make law with regard to acquisition and termination of citizenship. But in doing so, it cannot tinker with the provisions as contained in Part 2. That is my argument.
So it has to be, that means the exercise of power has to be done, keeping in view, my lord, the Part 2.
All right,
Yep.
now we are left with your argument, the last argument on part 3 now,
Yes.
where you are saying that it is stillborn. Tell us now, why is it stillborn?
Yes. Now, my lord, it is stillborn for the simple reason it is violative of part 3 of the Constitution. It is violative of
But
part
this is
14.
tautological. This is tautological. Anything which is violative of article, you
This
can't
part-
say it is, but then you have to still show us why it is violative of part 3.
It is violative of part 3 because it is violative of Article 14, as I have already submitted, my lord. It is violative of Article 29, which my learned friend has already
That's
said. It is violative of Article 21, which my learned friend has already.
Therefore, stillborn according.
Therefore,
It is void.
Yes. To that extent, it is void.
All right. Thank you, Mr. Chaudhary.
But there,
What is the next point? Then
Yes.
tell us now. Next the point. What is the next point?
yes. Next point is, my lord, that is most important. Article 355.
Yes.
Now, in Sarvananda Sonowal's case, my lord, at para 63, at page 70696 of part 4, my lord, volume 4,
Para 63. Right.
para 63 at page 7096.
Right.
This honorable court has said, my lord, that there is an external aggression / my lord, there is internal disturbance on account of unabated influx. Therefore, time has come for Government of India to invoke 355.
Yes.
Now, my lord, if 355 is to come to the rescue of the people of Assam, can we conceive of such a legislation? On the contrary, my lord, this honorable court, while upholding Armed Forces Special Powers Act, has held, my lord, that such a legislation has become possible only because of provisions like 355. So if 355 is
Supposed to protect the interest of the people, then, my lord, the actions has also to be commensurate. Not to, my lord, make illegal immigrants foreigner, that too at the cost of the indigenous people of the state. So that is how, my lord, by invoking 355, Government of India should have made certain
That point is
stringent provision, my
You're
lord.
right. That point Mr. Dewan also made.
Yes.
We'll have to hear the other side.
Yes.
That point is already
Yes.
made. Yes.
Then, my lord, I'll come to, my lord, will kindly permit me to place section 5(2) of the Citizenship Act.
5(2).
Yes.
two, three aspects on Citizenship Act. I'll just, within your half an hour time, my lord, I'll
No.
conclude. So, Lordship said,
15
Lordship,
minutes now. Yes.
if Lordship would kindly come to 5 subsection, 5, my lord, section 5.
The alternative benches will be discharged for the day. So the members of the bar who are waiting for the alternative benches need not wait. You're most welcome to hear the interesting arguments, but you're not compelled to. Yes.
5(1), my lord, subject to the provisions of this section and such other conditions and restrictions as may be prescribed,
The central government may, on an application made in this behalf, register as a citizen of India any person, not being an illegal migrant, who is not already such citizen by virtue of the Constitution or any other provisions of this Act, if he belongs to any of the following categories. Please come to B, my lord. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. That means under the scheme of section 5 of the Citizenship Act, my lord,
Right.
it is only people who is outside undivided India, he can be conferred citizenship by registration. Can we visualize a situation under the same very statute where, my lord, people from undivided India are being sought to be given deemed citizenship?
you must have overlooked this aspect. So, therefore, my humble submission is, my lord, is a total non-application of mine on the authority, my lord. Although, my lord, when it comes to challenge to a legislation, whether that ground is available, that is also another point. But kindly see, my lord, a person from undivided India, he cannot be conferred citizenship by registration.
On the contrary, by the same act, by section 6A, now a deemed citizenship is sought to be given.
There's a little problem with this argument because
Yes.
any legislature, forget its parliament, even the state legislature, when the state legislature enacts a law, it is not bound by the existing provisions of the law. it is subject to the constraints of the Constitution. So in the same law, the legislature can make alternative provisions. They can make provisions for eventuality A, they may make provisions for eventuality B, and this applies across the board, whether it's a tax law, it's a land law, it's a planning law, law on education. The legislature is not bound that, oh, we have already enacted this provision, namely that citizenship by registration can be only if you are a resident outside undivided India. This does not prevent Parliament from making a law which in effect grants citizenship by registration to a person even in undivided India. Of course, your point still is that you can't therefore confer citizenship on illegal immigrants. That point is a separate point. But I'm just telling you that there is no such constraint on the power of Parliament or the state legislatures within their dominion. State legislatures they are not bound by a previous provision which they have enacted.
But still, my lord, same act says undivided India out.
I know, but
it says
that's not your best point.
Anyhow, my lord.
I
felt, my lord, this is a point
that's
I
not your
need to
best
point
point.
out.
Yes, you made the point, we have
Yes.
made a note of it,
Now-
but that's not your best
Now, my
point.
lord, second point is, Article 9 envisages that there will be no dual citizenship.
All right.
Now, none of these, my lord, beneficiary of deemed citizenship, they have renounced their citizenship. At least there is nothing on record. Government of India in the council has not brought on record anything to suggest that these people had renounced citizenship.
All right, you've made the point.
Yes,
Last
that
one.
is, my lord, in terms of the act as it stood on 85, my lord, a pre-amended act.
Fortunately, they are not claiming dual citizenship. That's the difficulty.
No, my lord, the effect is there.
Effect is
Effective,
there
my
that-
lord, they are today they are citizen of Bangladesh, they are citizen of India.
Become a citizen, then
Yes.
that bar will
Effect is
come
that.
only after being a citizen of
Yes.
India. You opt for something, then bar will come.
Then, my lord, the other aspect on the Citizenship Act is my lord, that no mechanism has been provided, that my learned friend has argued,
Yes.
so I'll not make that argument, my lord. And my lord, as prescribed by section 5(2) of the old act, my lord, 6A permits deemed citizens to become or acquire citizenship without taking oath of allegiance to the constitution. Under the act 5(2) as it.
I think, Mr., you've made your point. Now let's hear
Yes.
Mr.
So there's
Thank you.
one more point, my lord.
Yes.
Finally. Now, my lord, assuming, my lord, process, assuming in a given situation, lordship is not inclined to, my lord, interfere with section 6A. Now, my lord, I have an alternative prayer, my lord. Now, lordship knows Government of India constituted a committee headed by a retired judge of the Guwahati High Court, Justice B.K. Sharma Committee, to provide measures for providing safeguards in terms of clause 6 of the Assam Accord. The committee has submitted its report, my lord. We have brought on record that report. That report, my lord, where the committee has suggested certain measures, including, my lord, for protection of the political right of the people of the indigenous people of the state. Can I just take your lordship, just 2 minutes time, my lord? Yes.
Where is it? What is the
Yes.
page?
My lord, the report is at page 1400 of volume 4, my lord.
One 1400.
1400, my lord. And if your lordships would kindly come to page number 1405. If your lordships would kindly come to, yes, 1405.
Yes. No, 1405 of volume 4, is
Four,
it?
my lord. I read it, my lord.
Yes.
The committee was constituted by notification reproduced below in respect of clauses 6 of the Assam Accord. The committee initially consisted of 13 members with Joint Secretary, Northeast Minister of
Where are you reading?
Yes, page 1405, my lord.
That's the notification. Oh, yes,
Yes,
okay. Okay.
introduction, my lord, on top.
So what's the point that
Yes.
you're making? You need not
Now-
read out the whole report. Tell us
No.
what the point is.
Now, the committee has suggested, or rather suggested certain measures to be taken by the government of India.
Show us those measures.
Yes. My lord will kindly come to page number 1412, my lord.
Take us right through to their conclusion because that
Yes,
will be
yes,
in your
yes.
favor.
That I will.
We'll put it to them.
Yes, yes.
So Chaudhary, the reason we are rushing you is because these factors are already in our mind. We want to
Yes.
put it to the government of India.
Yes, yes, yes.
This last point which you made, what measure are you taking?
Yes.
These are certainly things which we are going to we are going to place before the
Oblige, my lord.
we are going to ask the government
Yes.
of India.
Yes, please come to 1452. Seven point four on top, my lord. Measures to protect Assamese and other indigenous languages. So for protection of the language, my lord, under this heading, some measures has been given.
And what else? On this very aspect, what is they said?
Yes. Kindly see, my lord, at page 1453.
Go to page 1456. I mean, if yes, 1456.
3, my lord, regarding the language part, 1453. Assamese language shall continue to be the official language of Assam as per the provisions of the Assam Official Language Act.
That does
Throughout
not
this
fall within the
expression.
purview of the Constitution Bench reference. Go to page 1456. There's something in your favor.
Yes,
Implementation
yes,
of Assam.
I'm obliged, my lord.
Just go to 1456.
Reservation in employment under the central government.
We can't, this is not within our ambit. We can't direct the government to make reservations.
Other measures to
Protect, preserve, and promote the cultural, social, and linguistic identity.
Go to 7.6.1, implementation of the Assam
Yes.
Accord.
committee noted that Assam Accord is yet to be fully and effectively implemented, and even after 35 years of its signing,
It is felt that complete implementation of all clauses of Assam Accord, especially clauses 5.1 to 5.9 and clauses 7, 10 and 11 are essential for the safeguards to be provided under clause 6 of the Assam Accord.
yes. Then, my lord, 7.6.2, my lord. Reservation of seats in parliament.
That's not within the ambit of the reference. Let's skip it.
No, my lord,
It
they
may be
have
good
suggested,
political talk, but it's not certainly constitutional talk for us to
my
decide.
lord, they have also suggested measures for amendment of the constitutional.
We can't direct Parliament to amend the
Yes, yes,
Constitution.
yes.
So what's the point in, taking
Yes,
time on
yes.
issues which don't fall within our remit?
Yes.
Let's go to what we can do to really.
Yes, then my lord will kindly, my lord, basically, my lord, if I'm correct, my lord, they have suggested measures for protection of the language and culture. Then, my lord, employment, then land rights, and my lord, political right by suggesting measures for reservation of seats in the assembly and parliament.
All right, we'll broadly, we'll take care.
As has been done in case of Sikkim and other states, my lord,
Fair enough.
there are
We-
special
We got the
provisions.
point.
for them.
We got the point.
Yes.
Thank you, Mr. Chaudhary.
One last point, my lord. 2 minutes, my lord.
this report, 1462, Lord Chairman, only said.
You just said that.
Yes.
In fact, I'm also on 1462.
Now what?
See, there are two things which we have.
One final point, my lord. With the common someone like also not please. My lord, lordship has seen that expression detected to be foreigner means a foreigner detected under Foreigners Act and this Foreigners Order.
Right, right.
Now, my lord, by referring to, my lord, Article 13 of the International Covenant on Civil Rights, which was referred by the Honorable Court in Sarvananda Sonwal 1, my lord, I have already referred to paragraph 75 where Supreme Court has said, my lord, the benefit of due process of law can be conferred only to a citizen who lawfully enters. An illegal migrant is not entitled to due process of law. Now, kindly see, my lord, in Sarvananda Sonwal in paragraph 86, 3, after striking down, my lord, the IMDT Act, this Honorable Court gave a direction that now onwards, all the acts, because by virtue of section 4 of the IMDT Act, which was given an overriding, power, my lord, all other acts were in limbo. So therefore, my lord, it was ordered that now onwards, the detection of the foreigner will be done under Foreigners Act
10 of 1950, etc. Meaning thereby, my lord, when it comes to person who has entered lawfully, his case would be considered by my lord Foreigners Act. And when it comes to my lord illegal migrant, his case would be considered under my lord 1950 Act. Now by confining the class of persons only to be covered by Foreigners Act, my lord, the purpose of this act has been, taken away. How can that be done, my lord?
We consider that.
So
Thank
therefore,
you.
my submission is, my
Got the
lord.
point, Mr.
Yes. Therefore,
Thank you. Mr. Chaudhary, we have to get on now. Yes, Mr. Ansaria, please come.
and my lord, there is one judgment of the Supreme Court which I wanted to show, my lord, which I am not doing, my lord. What I have done,
What
my
is
lord?
the citation, Mr. Chaudhary? What judgment?
No,
you-
my lord, there is a judgment on Article 11, which other side will definitely rely upon, which I wanted to distinguish it, my lord. In my written argument, my lord, from page,
Keep your powder dry for the rejoinder. If they cite it, you will have to distinguish it. Let them
Yes.
cite it.
I thought, my lord,
All right, which is the judgment?
my lord, Izar Ahmed's case.
Izar Ahmed.
Yes.
What does it say?
My lord, Izar Ahmed was a case where, my lord, it was in the context of Article 9 read with Section 9 of the Foreigners Act. Sorry, Citizenship Act. There is a case of
Izar-
cessation of citizenship.
That takes the view that Article 11 is untrammeled by the provisions of the earlier
Yes.
article.
But there was no occasion, unlike in the present.
Let them cite it.
My lord will kindly, in my written argument, my lord, from page 3 to 43, I have dealt with all the 13 points formulated by the referral bench, my lord. Page 3 to 43 of my written argument
Thank you, Mr.
of volume 1.
Thank you, Mr.
And in fact, all the case laws and all I have dealt with, my lord.
Yes, thank you, Mr. Chaudhary.
I am
Yes,
deeply obliged.
Thank you. Yes, Mr. Ansaria.
I am appearing in writ petition 68 of 2016. And Lordship would find my written submissions, my lord, in volume 1, page 143. Volume 1, page 143, my lord, my written submissions are there. With an index, my lord, with the points which are there, my lord, which I am going to.
Mr. Chaudhary, what is the page of your written submissions, volume 1?
Page 3 to 43, my lord. Page 3 to 43. Tell you in details, my lord, all the points and both in foreign and
Mr. Shyam Diwan's written submissions are volume 1 page.
Mr. Diwan.
I'll just give that to you.
Yes.
I remember it's sort of subsumed in the index, but I'll
All
indicate.
right. Any junior can also tell us on just one. So we'll just make it so we don't.
Yes, my lord, though, my lord, I'm so sorry.
4 to?
44. Just this section.
Pages 44 to 142.
Yes, pages
Volume
44.
This is the name.
Got it.
144. Reconciliations are in
Volume, yeah.
हाँ.
अभी बढ़िया करते हैं ना. It becomes so easy.
page 44 to 140.
It says on behalf of petitioners, no, it doesn't have the name, that's what we are looking at. My lord, though my written submissions are in writ petition 311 of 2015, it indicates that. But as you pointed out, that was mainly on NRC, my lord. So I'm not going that. That's why I said, my lord, in 68 of 2016, the prayer of 60 has been there. Lord Submit treated as a written submissions on 68 of 2016. Let me first formulate the points, my lord, which
Yes, that would be nice.
Lord, the first, my lord, or it's sort of an index, my lord. The jurisprudence principles internationally recognized on immigration law vis-a-vis citizens. there are 6 principles, my lord, which I will just tell your lordship. My lord. That's the first, my lord, principle which I will be addressing your lordship, my lord, which is subject to your lordship permission. Secondly, my lord,
No, once again, jurisprudential principles.
principles internationally recognized on immigration laws vis-a-vis citizens' right. They are all part of my, my lord, written submissions. I'll give the para numbers also, my lord. I'll develop each one of them, my lord, subject to your lordship permission.
All right.
Second, my lord, the global refugee policy, my lord, as my lord as declared in United Nations refugee policy, my lord, 1951, refugee policy of 1951, to which 146 members are signatory. India is not a signatory. Recognizes only right to abode and not to right of citizenship.
Right is?
Right to abode with basic human rights, my lords, such as food, education, health. I'll develop that, my lord.
But Mr.
Yes.
Ansariya, what that means is no individual can move a court
Yes,
relying on a international covenant
my lord.
and say you are bound to confer citizenship on me. No
Look,
individual has the right.
I'm-
But this can never preclude the sovereign right of a nation.
I'm not saying Parliament is not sovereignly competent on this. I'm just broadly saying that what are the internationally recognized principles on that. But I cannot get a Mendamal or a seizure from your lordship that 6A must be stuck down on this. But these are the broad principles my lordship will keep in mind while interpreting. And I'm going to submit that these are part of our preamble and constitutional ethos.
All right. Second,
I'll develop that.
third point.
2. 3, my lord, as Mr. Chaudhary has said, my lord, I will demonstrate that with article there. At section 6A in effect amends article 6 of the constitution. I'll show that how. And it could not have been done without going through the process of 368.
Amendments, Article 6.
In effect, Article 6 of the Constitution, 6 and 7 of the Constitution, my lord. It amends Article 6 and 7 of the Constitution in effect. I have got, my lord, the chart, my lord, by how it has been amended. In effect. Fourth, I'm so sorry. My lord, Mr. Diwane said you cannot discriminate within homogeneous group. I'll show some materials to show, my lord. Assam, along with 4 border states of the eastern part of the country, my lord, are homogeneously placed with materials to support that Assam has been singled out and discriminatory, my lord. This so far if you're making it applicable only to Assam. The effect is, my lord, not only that they are staying back, they are coming from the neighboring states, my lord. If your lordship knows, my lord, from Guwahati to Shillong, if your lordship go, one side is Assam, one side is Meghalaya. If you are in this part, you are Indian citizen. If you are in this part, you are an illegal migrant. So all that it requires, cross that road and claim citizenship. And I will show, my lord, from the materials on record. What is the extent of, my lord, illegal migrants in those states, and what is the extent of illegal migrants in Assam, and what is the extent of border, my lord, of the 4 states and us, to show they are homogeneously placed, my lord, and you have discriminated only Assam, my lord, quad that. I'll show that. 5th, my lord, as Mr. Chaudhary said, I'll just develop that little more, that subscribing an oath of allegiance to the Constitution of India is a basic feature of the Constitution. And the persons who have come, they have not come from Bangladesh, my lord, because Bangladesh is not born on 26th March 1971. Bangladesh is born on 26th March 1971, not on 25th March 1971. And on that day, they are the citizens of Pakistan, in which, my lord, they prophet. Says, Prophet Allah is the only person who has made the earth. I'll show that, my lord, I have quoted it. So unless they renounce their citizenship of another country, which believes in a, my lord, religious, particular religion, you cannot become a citizen of the India, or which is a, my lord, a secular country, without subscribing an oath of allegiance. And that is what is required in section 5 and 6, my lord, that wherever you become a citizen by naturalization.
What's the next point?
Next point is, my lord, the India has a refugee policy, my lord, qua Tibetan, qua Chakmas, qua Tamil, and qua Rohingyas. None of the refugee policies, my lord,
confer an automatic deemed provision for conferring citizenship.
India has a refugee
Well, all these are there on record. I'll show that.
For
Give the pages. Policies for Tibetan, for Chakmas,
For Tamils and for Rohingyas. Sri Lanka, yes, of course. There are definite policies of rehabilitation for the refugees who are these four groups, my lord. None of them confer an automatic citizenship, much less a citizenship by an application. And this is discriminated. My lord, first, and the finally, my lord, BK Sharma committee report, Lordship has seen 1462, my lord. What it says finally, my lord, it says, in case it is to, in the meantime, what is to be happen. And I will give a case law, my lord, to your lordships on discrimination under Article 14. I'll give you a list of.
Hansaria,
Yes.
can you go straight to your third point, that section 6A in effect amends Article 6 and 7?
I'm grateful to your
And
lordship.
then we come back to your earlier.
Please, your lordship.
Because
I'm
those are
extremely grateful.
Showing us the material exception.
Done. I've typed Article 6. I've engrafted 6A. How it is amended. To just, it will be easier for me to demonstrate that. It has Article 6 and how Article 6A has been incorporated there. Just give it to that. I haven't done it. Just give it.
What are the track changes in the
No,
document?
this is Article 6 of the Constitution,
Right.
which is there, my lord. What I've struck off is what is the effect of section 6A. And my lord, how it has been, my lord. So Article 6, if your lordship kindly keep the Constitution side by side. I have typed Article 6, my lord. And whatever has been changed because of section 6, I have struck off. And in italic, I have put what is the section 6A has superimposed on that. So lordship may kindly keep side by side. Article 6 of the Constitution says right of citizens of certain persons who have migrated to India from Pakistan. What 6A says, Lord, who has migrated to Assam from Bangladesh. In effect, I'll show section 6A also, section 6A. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be citizen of India at the commencement of. So there is a deeming, by way of a deeming fiction, my lord. A person who would not become a citizen of India is deemed to be a citizen of India in respect of those persons who have come from Pakistan. Now, my lord, this specified territory is a part of Pakistan. Is a 25 March 1971 is the cutoff date, on which date it is a part of Pakistan being East Pakistan. Bangladesh is born on 26th of March 1971.
Just one second.
In paper, 26 March, in actuality, 16 December 1971, after India won the war.
What is the date on which India recognized Bangladesh?
16 December 1971, when India won the war.
But then what is the relevance of 25th March?
Because, my lord, Bangladesh declared itself to be a country.
It declared its independence.
Itself to be independent on 26th March.
But we recognized Bangladesh in December.
December, because after Indo-Pak war, my lord. From 11 December to 16 December. And it declared its independence on 26th
So on
March.
25th March, according to you,
Yes, my lord.
Bangladesh was an integral part of
Pakistan. And I have got
And if you're from Pakistan,
yes,
then the only date was 19 July 1948.
please, your lordship.
But even there's a problem in your argument.
Yes, my lord, let me understand.
I mean, theoretically,
Yes, my lord.
Parliament may not do it,
Yes.
but it was always open to Parliament to say, what does Section 6 do? Oh, sorry, what does Article 6 do?
Yes,
Article 6 is qualified at the commencement of this constitution.
my lord.
That is to say, persons who had already migrated from Pakistan, in fact, this I must share, just as Brother Sundaresh pointed this out to me a short while ago. Persons who had migrated from Pakistan prior to the birth of the constitution on 26 January 1950, they would be conferred citizenship, or they would be deemed to be citizens,
Deemed.
subject to certain conditions.
Yes.
One was either of the parents was a
Yes.
citizen, or they were either the parents or grandparents were born in India, Then B, in the case where such persons so migrated
Yes,
before 19 July 1948 and
Well-
has been an ordinary resident of the territory since
my lord.
the date of the migration.
Yes,
Right? Because 19 July 1948, they probably took as the partition
yes, my
appeal.
lord. Yes,
approval.
yes.
Therefore, what Article 6 does is to confer citizenship on a class of citizens, on a class of persons who had migrated from Pakistan prior to the date of the adoption of the
My
constitution.
lord.
It freezes it as that. But that does not prevent or does not dilute the power of Parliament under Article 245 and 246 and entry 17.
Entry 17.
And particularly in the context of Article 11, even to confer an extended citizenship on persons coming from Pakistan itself. I'm saying,
My lord.
forget Bangladesh, but test it only for the purpose of a hypothesis. I'm not saying that they will do it.
Yeah.
But there's nothing to stop Parliament from saying
Ma-
that we are now, in exercise of our power under Article 11, also conferring citizenship on a group of persons from Pakistan post 1948. In which case, the fact that technically on 25th March 1971, Bangladesh was still a part of Pakistan
My lord.
would not really affect the power
May-
of Parliament.
My lord, may I meet that, my lord? I'm extremely grateful to your lordship, my lord. What Article 6 and 7 says, my lord? By deeming fiction, it could have said, my lord, on before the commencement of the constitution, as Article 3 has said, Article 5 has said, my lord, all persons born before the commencement of the constitution, it has chosen to fix a date, my lord, of 19th July 1948, who will be deemed to be a citizen, otherwise they will not become a deemed citizen.
So you are reading Article 6 as exhaustive.
Is exhaustive so far as deeming fiction is concerned, my lord, of people coming from Pakistan. In effect, my lord, does it or does it not, lordship would test it, my lord, amend the constitution.
All right.
Say, my lord, that those who come before 1st July 1966 and come to Assam from Bangladesh would be deemed to be citizens. I have no difficulty, my lord. They can make an application, naturalization. Parliament has made section 6, 7, etc., my lord. No difficulty. But can you make a deeming provision, my lord, by saying, no, I'm so sorry.
Immigration.
But I'm so sorry. So I'm so sorry. So my submission, I'm so, no, lordship would test it. I'm so sorry. Yes,
I've understood your argument
Yes.
right. We'll phrase it in a proper way.
yes,
Article 6
Yes.
provides for a deeming fiction by virtue of which persons who had originated in Pakistan were given conferred citizenship, provided they met the cutoff of 19 July of 1948,
my lord.
or in some cases even beyond. When Parliament legislates under Article 11 in respect of persons originating in Pakistan, you cannot introduce any other deeming fiction.
My lord.
Because that deeming fiction is provided by the
Parliament,
substantive
by
provision of
the Constitution.
And on that day, 25th March 1971, these areas in specified territories were a part of Pakistan, and therefore Parliament cannot really, by a deeming fiction in exercise of its power under Article 11, introduce a contrary deeming fiction.
My lord,
See, that's the point. We'll hear the other
Lordship
side.
would test my argument, just one more sentence. Suppose, could the Parliament have said, my lord, 25th January 1950? 26th January was Article 5 say commencement of the Constitution. Lordship would test my argument, my lord. Could the Parliament have said anybody who entered on till 25th January 1950? It could not have, my lord. If it could not have said 25th January 1950, which is a day prior to the commencement of the Constitution, it definitely cannot say, my lord, on 1st January 1966. On what basis, my lord? Because it is in the teeth of Article 6, my lord. If Article 6 completely, my lord, encompasses the persons of deemed migration who has come to India from Pakistan.
That actually what you said is right. Your argument would be correct,
Yes,
provided we accept the
Yes.
hypothesis that Article 6 is a complete code
yes, my
in
lord.
respect of persons who are migrating from a territory which was in Pakistan.
By deeming fiction, again, my lord, I'm saying by application
If you
differently.
are right that Article 6
Yes.
is a complete code, then there may be some substance.
Yes,
But the whole
Yes,
basis
your
of your
lordship.
argument is
Yes.
Article 6 is a complete code.
yes, my lord.
Therefore,
Because,
you can't, it's somebody coming in from a territory in Pakistan, Parliament cannot legislate to the contrary by deeming fiction.
by deeming fiction, that's fine, it's a complete code because.
That's the point. We'll hear
because-
the other
Yes, my
side.
lord, because it clearly.
Let's go to the next.
Very well, Lord. Because if your lordship see now clause B also, my lord, which I have given it in chart. Because this is a matter of, my lord, great importance, especially for the people of Assam, my lord, as your lordship are hearing very patiently, very grateful to your lordship, my lord. Lordship heard the 370 matter in the same way. Clause 2 also, lordship would kindly see, my lord. I'm so sorry. Show that map next.
Technically, you may be right that it was part of Pakistan on 25th March.
It's factual, my lord. It's, my lord.
I mean, can there be?
On a sovereign
If you
principle,
look
it
at
is right, my lord.
If you look at the history of the liberation of Bangladesh.
My lord, that started thereafter, my lord. That's what I'm saying, my lord. It started, my lord, the war is on in December 2000, in December 1971, Indo-Pak War.
But
So,
Parliament,
my lord, people have flagged, my lord. People, Rongias have flagged.
can you attribute to Parliament when they enacted Section 6A that they wanted to confer citizenship on citizens of Pakistan?
I don't want to say that, my lord.
Then-
No, my lord. But my lord, they have, my lord. I'm not saying.
Parliament
My
is
lord,
conferring
my lord, what
citizenship
is the
on
intention of
persons who are
Parliament,
coming
lord?
from
My lord,
Bangladesh. They were conscious of the fact
we
that,
cannot.
you know, Article 6, let's also, we can't look at constitutional provisions in the abstract.
Lordship will not,
Article 6 deals with the travails of partition.
my lord.
There are a large number of persons
Yes.
who are fleeing
Flee-
Pakistan
fled
into
from-
India
Yes.
because of the sheer scale of violence which took place at partition. So Article 6 therefore protected those people.
My lord.
It even extended it beyond July 1948. Therefore, Article 6 was a complete.
No, it
and
has
when
not
Parliament
extended.
enacted
19
Section
July 48 is
6A,
not extended any
the
point of
last
time.
thing which I think we can attribute to Parliament was that
No,
they were
my lord,
conferring
we cannot
citizenship on
attribute
citizens of
Parliament to Melis or
Pakistan.
anything, my lord. That's, if, lord, the question of Melis doesn't come to Parliament at all.
Obviously, but so therefore they are looking at, Parliament was looking at the human suffering which
Lord,
was
there are
caused
human
with-
sufferings and wrong, yes, my lord. I'll show to you, lord, say how they are opposing. And that's why refugee policy comes in, my lord. They are even saying Tibetans, they are even saying Tamils, and they are not giving citizenship, my lord.
That's a different issue.
My lord, what I'm saying, lordship are testing on constitutional principles.
This is not the subject matter.
Yes, yes.
India is not a signatory to
Yes.
the Treaty Convention. Let's not go into it.
Very well, my lord. I'm not going into it. I've said, my lord, India is not a signatory to it, so they cannot seek, my lord, whether they can make a law, Parliament can make a law, my lord, in the teeth of Article 6 and 7, my lord. That's why, if a lordship permit me to show further, my lord, it will show further that in effect they have further.
So, Mr. Ansari, we have to make basic principles of constitutional law to be very clear in our mind.
Yes, my lord.
If Parliament is entitled to legislate to confer
It can.
citizenship, it is not bound to recognize the refugee status and confer citizenship on people of every hue and dimension.
Yes, my
There may
lord.
be people from different parts of the global south
Yes, my lord.
who want to come
It's
into
a human
India.
problem globally. There are
Right?
3.5 crores.
Parliament is not bound
Refugee-
to pick out everybody that, look, we'll do it for every, because Parliament can certainly say that, look, we'll look at the impact on our resources,
Yes,
our
my lord.
public
That's
infrastructure.
what the principle. It is, and it's a quotation, my lord. You cannot simultaneously have free immigration and welfare state from a Nobel laureate, and which is, my lord, lordship sees, my lord, this quotation. It's recognized the main argument, my lord, which I'll be developing to your lordship, my lord. Now, my lord, B proviso further says, my lord. B2, may I read this, my lord? This Article 6 argument is, my lord, my best argument, perhaps your lordship may consider. In the case where such person so migrated on or after 19 July 1948, then my lordship may ignore that part, italic part. He has been registered as a citizen by an appointed so-and-so. Now, proviso, provided that no such person shall be so registered unless he has been a resident in the territory of India for 6 months immediately preceding the date of his application. So what it requires, my lord, if you have come after 19 July 48,
You have to be there for a minimum
for
period of
6 months, all these requirements are completely given, even if you are there on 24th of March 1971 in Assam, 24th of March.
No requirement of.
Nothing, my lord. This is a mandatory requirement of Article 6, my lord, and these are very important fundamental principles, my lord, which the Constitution has made. And similarly, my lord, Article 7. Article 7 is also breached, my lord. And it's a complete bar, my lord, that the person who has gone to Pakistan shall not be deemed to be a citizen of India. If your lordship see Article 7.
Again, there is a problem with the argument.
Yes, my lord.
6A
Yes, my lord.
was introduced in 1985,
My lord.
right?
My lord.
By the time that it was introduced,
Yes.
when 6A2 came into force,
Yes.
at the least 14 years had gone by.
Yes,
The
my lord.
cutoff date for entry into India under 6A2 is 25th March 1971.
My lord.
Between that date and the date on which Section 6A is enacted, 14 years have gone.
14 years. Yes, my lord.
6A2 clause 6A3 clause B
My lord.
says, has since the date of his entry into Assam been ordinarily resident in Assam.
Yes.
In other words, a person who had entered into Assam between that period 66 to 71
My lord.
would have been ordinarily resident in Assam at
Yes.
the least for 14 years, at the highest for 19 years. So, tacitly, therefore, Parliament is
Yes.
in that proviso, it is 6 months.
Yes.
By enacting that legislation in 1985, they have ensured that somebody has been resident for at the least 14 years.
My lord. My lord. But what I'm saying, my lord, this, I quite say, my lord, see, my lord, what is following from my lord, the Chief Justice. But there is a specific requirement which is, my lord, Parliament 368 route is possible, my lord. Whether 245 route is possible or not, that's why, lord.
That will have to
Let your lordship,
We'll have to
take your
go.
lordship, see Article 7 also, my lord. For Article 7, my lord, which is there in the same chart, my lord. Article 7 for a minute. Article 7. Right of citizenship of certain migrants to Pakistan, notwithstanding anything in 5 and 6, a person who has or after the first day of March 1947 migrated from the territory of India to the territory now in Pakistan shall not be deemed to be a citizen of India. So, my lord, anybody who is in Pakistan, my lord, on this date, after this date, he will not be deemed to be a citizen of India. And all these persons who are there, my lord, were in Pakistan, my lord, on the 25th March 1971, the cutoff date. Now, proviso. Provided that nothing in this article shall apply to a person after being so migrated to the territory now included in Pakistan, has returned to the territory of India. Now, my lord, this is what the article says. India, under a permit for resettlement or permanent return, issued thereunder by the authority of any law. Now, my lord, what the Act says does, my lord, return to Assam on or after 25th March 1971. This is in effect, my lord, the amendment, my lord. That's my submission. Your lordship has to consider that, my lord.
All right, now let's go to the
Yes,
next
my lord.
point.
Now, my lord, would your lordship
Now,
permit me?
rapid fire, we'll complete the next point, sir.
My lord. Second, my lord, if your lordship, second, my lord, my first was, my lord, that there are certain internationally recognized.
You have put them in your submission.
My lord,
those,
would your lordship just permit me to say, formulate those 5 points?
are they in your submission?
Which are there in my submissions, but
Yes,
I want one, their submissions are in 2 pages, just one sentence for each.
All right.
First is, my lord, you cannot simultaneously have immigration and free immigration and welfare state. That's the first principle, my lord, internationally recognized, which is there in para 38 of my written submission. Second, my lord, admitting strangers should not significantly harm the current members of the community. That's the second principle, my lord. If it significantly harm, and I'll show to your lordship, 18% are, my lord, the immigrants, my lord. On the date of 2001, we have figures available for 2001. I'll demonstrate that, my lord. None of the bordering state it has that much of, my lord, immigrants. I'm not saying, my lord, which caste, which religion, etc. Illegal immigrants, as per the official figures given by the Home Minister on the floor of Parliament. Third, I'm so sorry. Third principle, my lord, unrestricted immigration threatens the continuity of identity of the members of the nation.
Unrestricted immigration.
Unrestricted immigration threatens the continuity of identity shared by the members of a nation. Because we have a continued identity, we are secularism. And I'll show to a lot of persons who have come have an oath of allegiance to a constitution where they where they recognize Islam as the final arbiter. I'm not saying anybody cannot, but we do not share that, my lord, as in India. Fourth, my lord, human rights cannot be extended to include within its ambit the right of citizenship.
Just repeat.
Human right cannot be extended to include within its ambit right to citizenship.
Yes.
As citizenship is a political right and not a basic human right. Thus, my lord, there cannot be any immigration policy which has an adverse impact on the domestic cohesiveness.
That's the fifth point.
That's the fifth, my lord. And there's one more, sixth. That's sixth.
What is the fifth, Mr. Bahansali?
There cannot be any immigration policy, and this is part of basic structure. I'll show to you, lord. Immigration policy which has adverse impact on domestic cohesiveness. It is the fraternity part, Lord Mr. Shamdevan has said. Or a threat to national identity. Yes, I'm so sorry. Or identity of a federal unit of the nation.
Threat to national unity or
identity of federal unit of a nation. Or is against national economic interest. Look, these are all flows from the preamble itself. We are a federal structure. We have fraternity amongst ourselves. And finally, refugees may not, under Article 21, because 21 is all person, any person who would compass, my lord.
Article 14 also.
Article 21, my lord, to every person, applies to, my lord, every person. Refugees have a right to abode with certain basic rights, such as education, food, health, and not right of citizenship.
All right.
And I have given, my lord, under the UN convention.
Actually, there
50
can't be any dispute about these propositions which you have laid down as a.
Tested
general
on these propositions, my lord, you are giving citizenship to persons which is affecting, my lord, the welfare activities of the state because there's a huge burden. My lord, immediately, may I come to, my lord?
That Mr. Diwan has made also.
Yes, my lord.
That is
Just
done.
can I show, my lord, would lordship come to volume 4A, page 3420.
Acharya, there can't be any doubt about these principles
My
which
lord.
you have laid down.
Now, if this I'm so sorry.
There's absolutely
yes.
no doubt about these principles.
My lord.
There is, no person can claim that, look, I'm a refugee, you shall give me citizenship.
My
If you
lord.
were to file a writ in a court under Article 226, that person would be turned out, saying that,
Yes,
look, where is
yes.
the right? You have to fall within the framework of Indian law to claim Indian citizenship.
My lord, my lord.
So these principles which you have formulated,
now-
they're absolutely unexceptionable. There's no doubt about
I'm
it.
grateful to your lordship. Lord, would your lordship kindly come to volume 4A, page 3420,
What is that?
to show, my lord, a map, my lord, of the northeast, because, my lord,
All right.
how many kilometers India, Assam has the border, my lord, and how much population it has.
Official map or?
Official, my lord, 3420, and I'll show MH, my lord, the map is from the map of India. The figures which I'm giving it in my written submissions are from the Ministry of Home Affairs, my lord.
4A.
3420 of volume 4A.
Just one second, let's all go to it.
This is just to show, my lord, how the Assam is located with vis-a-vis the other four bordering state.
No problem.
Yes,
4A, huh?
3420. And these are part of our written. If your lordship see, my lord, Bangladesh borders 5 different states. 3420. I'm so sorry, my lord. Perhaps, my lord,
3420.
3420. Just to give a topography of the area, my lord.
Yes.
It borders, my lord, West Bengal, Meghalaya, Assam, Tripura, and Mizoram. And how much does it, my lord? It is on the MHA, my lord, in my submission. I've just prepared some sort of a chart again for convenience, my lord. It is there in there. I've given the page numbers also here.
So Bangladesh's largest border is really with West Bengal.
Yes, my lord. It has, my lord, it has, my lord, 2,216 kilometers with West Bengal. And these are from the, my lord, I've given the source also. And they are part of my submission also, my lord. Just which page of the submission? These are part of my submission also, my lord.
But border with Meghalaya appears to be larger than.
That's right, my lord. So, my lord, that's what it's happening. People go to Meghalaya immediately, cross over the road, come to Assam, claim citizenship. That's a huge problem for Assam because if your lordship travel from Guwahati to Shillong, my lord, one side is Assam road, one side you have to only cross the road and to say claim citizenship of the country. If your lordship see below this, Assam borders 263 kilometers with Bangladesh.
In this map, where is Guwahati?
Well, Guwahati is Dispur. It's in Dispur,
Right.
capital. So it doesn't, the Guwahati doesn't border Bangladesh, but it borders, when you travel from Dispur to Shillong, you have, I'm so sorry,
Whether I want to know, when was Meghalaya created?
in 1971.
So before the cutoff date or after this cutoff date?
69, it becomes an autonomous state. And Meghalaya, lots would give me a minute, Lord. Northeast Areas Reorganization Act.
It became a UT for some.
Lord, it is 1969, it became an autonomous state within the state. And that became, Lord, under the Northeast Areas Reorganization Act, it became 21st January 1972.
So then this would be the Assam border only.
Yes, my lord.
Yes, it was an Assam.
Page 154. All these figures, my lord, which I'm giving it here, are part of this. I've given the source, and it is in part of my written submission, my lord, in paragraph 15. Yes, it became an autonomous state in 1969. 69 Act, I don't know that.
1869.
69, Assam, state within a state. It was a new concept which was developed. And then it became a full-fledged state in 71 Act with effect from 72. So, my lord, Assam has, my lord, 263 kilometer bordering. West Bengal has 2,216 kilometer bordering. Meghalaya has 443 kilometer bordering. Mizoram has 318 kilometer. Tripura has 856 kilometer. Now, lordship would see, my lord, the extent of illegal population in 2001, which is as per the statement of the Home Minister on the floor of Parliament. It is not from any individual studies, my lord. And these figures are there, a part of, my lord, my submission, and this is part of the statement of the Home Minister, my lord. Lordship would see, my lord, 50 lakhs are the population in 2001. out of 266 lakhs is the total population for the census of 61, 18% are, my lord, illegal immigrants. And you give citizenship to all. Where is that homogeneity? Article 14 has to have some meaning, my lord, not to an individual, to a group of individuals staying in Assam, claiming their ethnic rights, my lord. In West Bengal, 57 lakhs out of 801 lakh 8 crore. It is 7%. Meghalaya, it has 30,000 out of 23 lakhs. It is 1%. Mizoram figures are not available, my lord. Tripura has, my lord, 10%. So you're not giving it to, my lord, the person who has 1% or 7% or 10%. You're giving citizenship, my lord. What is the basis for giving citizenship? Mainly because you want its political issue, you have an Assam Accord. That does not satisfy the test of constitutionalism, my lord. That may satisfy the test of your political expediency.
You have taken the figures as of 2001.
Yes, my lord.
Huh?
2000, these figures
What is the figures of 2000 and of 1971? How many people are actually that we have put it?
No, that my lord friend is given about 5 lakhs. That it was stated on the floor of the house by a minister, my lord.
No, but they are going to give us the official.
Mr. Solicitor pointed out on that day, my lord. That was during the debate. Mr. Badlu Islam said this is the figures, my lord. But officially, my lord, as Mr. Diwana said, nobody has come out with the figures, my lord. We have the figure only of 1971 from S.K. Sinha report, my lord, who was the governor of Assam. We have figures from the Law Commission of India, and we have figures from the Home Minister of India. These are the 3 figures which are available on record, my lord, which I pointed out in my written submissions in paragraphs. In paragraphs, my lord, I have given those figures in paragraph 18 of my written submissions, my lord. These figures are given with the source and the links.
Actually, if you look at it, this
Please see, my lord, now the second schedule of the Citizenship Act. For a minute. Every person who wants to be citizen of India makes an application for registration under Section 5 or by naturalization under Section 6. They cannot become a citizen of our country, my lord, without subscribing an oath of allegiance as prescribed under second schedule. And this is Section 5 to 6, I'm so sorry, Citizenship Act, my lord. Schedule to the Citizenship Act. Act. Yes. Oath of allegiance, Section 5 and 6(2), my lord, are what? Application for by registration or by nature. Do hereby solemnly affirm or swear that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will faithfully observe the laws of India and fulfill my duties as a citizen of India. Now, my lord, in contrast, would your lordship kindly come to my written submissions, my lord, page 161 of that compilation, volume 1. What? Just a minute. None of the persons, my lord, who are given deemed citizenship, my lord, subscribe any such oath. In fact, my lord, they are born and, my lord, the subscribing an oath under the Constitution of Pakistan, which says, my lord, if your lordship kindly permit me to read para 9920, my lord.
Same applies to Section 6 also.
Same applies to?
Section 6 also. If you say so.
Yes.
The same applies to Section 6 also. Anybody who got
Yes, but 6. They have to make an application, subscribe oath. Thereafter, my lord, let them, my lord, this provision cannot stand scrutiny, my lord. At least they have to say, you have to subscribe oath to get a citizenship of my country. You do not subscribe oath and you give citizen to lakhs of people, my lord, by deeming fiction.
How it will impact the legality of the provision?
No, because, my lord, because we have a sovereignty of India, my lord. It's the basic feature, my lord, of our constitution. A person who believes, my lord, is bound by the preamble of his parent constitution, which says, my lord, sovereignty over the entire universe belongs to Allah alone, and the authority exercisable by the people within the limits prescribed by him in the sacred status. And whereas the founder of Pakistan, Qaid-e-Azam, Muhammad Ali Jinnah, expressing the will of the people, declared Pakistan to be sovereign Republic of Islamic State. Can a person who is subscribing this oath, my lord, become an Indian citizen without subscribing an oath of allegiance under Schedule 2?
It all depends on what Parliament assumed. If Parliament assumed that these people were fleeing their motherland,
yes,
because of the atrocities in the motherland, or for a variety of reasons, the violence, the atrocities.
My lord, all refugees, my lord, let me be very candid. All refugees, my lord, are people become refugees because they have to fled their home state, my lord. Nobody wants to leave their home for a good cause, under compelling circumstances.
Right, but then the last thing which the refugee wants to do is to still plead allegiance to the motherland, because they have left the motherland because of the conditions of the motherland.
No, that's what I'm saying, Lord. No refugees, which are 3.5 crore globally recognized under the UN figures, my lord. Refugees leave their home without a compulsion. Anybody who becomes a refugee is under compulsion, my lord. So can you give my lord? That's what I said, my lord. You can give a right to abort, which is a humanitarian human right. We have given, my lord, vaccines. My lord, Sri Lanka recent judgment recognizes that, my lord, India helped them with billions of dollars to come over the crisis. But for that, Lord, I will give that citation to the Constitution Bench of 5 judges of the Sri Lanka Supreme Court. In the judgment recognized, my lord, it is but for the help of India during that financial crisis, the Sri Lankan position would have been much worse. But all that I'm saying, all that I'm saying, my lord, all that I'm saying.
If it is an individual case, if they are deciding individual case, they can do. If this is on a contingency basis,
my lord,
the logic which you apply basis upon which second.
No, my lord, what I'm saying, my lord, if you cannot give it to individual, can you give to a lakhs of people, my lord, citizenship by fiction? My lord, anybody who, I'm so sorry.
So, my lord, my submission is, my lord, unless, my lord, you cannot become a citizen, you have to subscribe an oath of allegiance, which is basic, my lord, fundamental of
Okay,
the.
we've got the point. Anything else, Mr. Vahansalia now? I think you've wrapped up your submission.
Yes, my lord, I'll just finish it, my lord. Yes, my lord, as my lord, this court has struck down various legislations on manifest arbitrariness. I have prepared a schedule, I just to update it. I'll give, my lord, all these parts of their compilation with the lord, starting from, my lord, Honorary Sarkar, my lord, the Justice Vivian Bose judgment, it's a very, very illustrative.
That is not manifest arbitrariness.
No, it says, my lord, what will be the discrimination? Of course, manifest arbitrariness is Saraman with relevant paragraphs and the compilation pages, my lord. I am preparing, I'll just tomorrow morning, I'll give that 2 pages, my lord, where the relevant judgments and with the relevant paragraphs and the relevant compilation page numbers, my lord.
So dual citizenship, my lord, again, my lord, those persons who have been given, my learned friend has dealt with it. Article 9 requires you to denounce. Without denouncing, my lord, how can you become, my lord? They have not given up. Nobody has said, my lord, give me a citizenship. Lordship may presume that it is presumed, but ultimately somebody has to say, my lord, I don't want the citizenship of the country, I want the citizenship of your country. Lord, I cannot get a citizenship of anywhere in the world. But you can, by parliament, my lord, by deeming fiction, you give a citizenship of persons even you don't want, my lord. They can go back, they continue to have both ways, my lord. They stay here, they cannot stay here. So they claim citizenship of that Pakistan also, or now Bangladesh, or claim citizen of India, my lord. There cannot be any such law, my lord. You can choose citizenship at the same time. You have to denounce one and then to get another, my lord. And finally, as I said, my lord, if your lordship see, my lord, while Mr. Solicitor doesn't want, but there are refugee policies of this country, my lord. I have given those paragraphs, lordship may only make a note of this, my lord, that it has something to do, Mr. Solicitor, it has something to do with, my lord, if you persons who are in India from last 50 years, my lord, Tibetans, etc., you have not given citizenship, Tamils, you have not given citizenship, the Rohingyas, you have not given citizenship, my lord, Chakmas, you have not given, Chakma, there are judgments of this court, my lord, but again, against atrocities on them. But citizenships are not given, my lord, to the people. So country must have a consistent, my lord, refugee policy, my lord. You cannot, my lord, just say people of, so far as Assam is concerned, no policy matters.
All right, thank you, Mr.
Well, I'm extremely grateful for such a patient hearing, my lord, and I'll just give the start tomorrow morning. Okay. Lord, if a lordship has want to say something, then leave it.
Thank you, Mr.
I'm grateful to a lot.
Mr. Solicitor, would you like to start tomorrow morning? Because now we are almost in the wrap. That, it's just so that you will only barely open, otherwise if you start today, start tomorrow. So, Mr. Solicitor will argue first, then after that...
Thereafter, I'll make my submission.
Mr. Sibal would like to argue.
Mr. Kapil Sibal will be following.
And then Ms.
Solicitor, and after Mr. Sibal, I will argue.
Lord, I appear for ASU, which is respondent number 6 in the petition. Whenever I can have 5 minutes, I can sum up my arguments.
But I'll also request for 5 minutes.
Yeah, I would also only be taking 5 attempts.
If you can all, the others, apart from the solicitor, they've already filed submissions, Mr. Solicitor, Mr. Sibal, Ms. Jaising. The others, if you can just give us a page of just bullet points.
ASU is the party. In fact, the others
What I'm saying,
given our submission.
your submissions are filed? Shadan Saraswat also, Mr. Singh also, no difficulty there.
I think two of my friends are not on this side.
AG wants to argue. After you...
The learned AG may take some time, not very long time. He's out of station, he's coming, returning to.
But you can start tomorrow, Mr. Singh.
I will start.
Two of my friends on this side have given submissions. I'll give the page number.
My written submissions, both the matters in which Mr. Diwan has appeared and Mr. Ansari has, and they are on record. Apropos what fell from your lordships on Expulsion Act, that is also there in my written submissions.
Just give us a page tomorrow.
I'll give the page. And on the strict scrutiny doctrine which your lordships have to fell from your lordships, that's also covered in my written submission. I've given the judgments also.
Thank you.
Great. Please, your lordship.
Great.